Back to the hustle.
The city's meant to be yours, sweetheart. What are you gonna do to get it?
It's just the beginning.
The Penguin, streaming exclusively on Max.
Well, okay. Good morning, everyone. All right, was everybody able to get the transcripts that were forwarded by Miss Winfrey and by Miss Weaver? Okay. Great. And I don't know if y'all got word, Miss Love is a little bit delayed this morning. Mr. Atkins, are you able to point to where in the transcript supported Miss Love's argument on that objection?
Your Honor, I am currently not able to point to exactly where in the transcript supports the state's argument. I will be working on finding that, Your Honor.
Okay, or can you maybe communicate with Ms. Love?
Yes, Your Honor.
Okay. Matters for the court's attention this morning.
I think it's part of this. I just want to continue my argument on that motion, that's all. But I assume it's within what you're doing.
What do you mean?
I assume it has to do with what you just asked, Mr. Atkins. So I think it's part of the same motion, but I have other statements that I'd like to make to the court, that the court to consider. That's all. I could do that now. I'm not trying to blindside Mr. Atkins, but if it helps, I'll do it now.
So the 8:30 email that I guess y'all all got says she'll be here momentarily. Not quite sure what momentarily means. But
Yeah, Your Honor, my latest update is they should be in the elevator as I'm
okay.
speaking.
Then we'll just give them a couple of minutes.
Thank you, Your Honor.
And it's everybody that needs it or wants to have the Zoom link.
When was that sent out, Your Honor?
Should have been probably this morning. I think I can copy it and send it on that email that just got sent around if anybody needs it.
Your Honor, may I also be copied on that email?
Yeah, I'll just send it to everybody that's on the email from
Thank you, Your
on
Honor.
behalf of Ms. Eli. I don't even honestly know who all these people are. Some of them might be DA's office people. Good morning, Miss Love.
Yeah, and I think that, one person,
Revenge ain't always about blood. Trust me. That's a fate that's worse than death.
At my lowest, I was barely eating and overexercising while still gaining weight.
Under a wholly unrelated matter,
Okay.
would you just consider possibly not holding court on election day this year?
I'll consider it.
Thank you. That's all I ask.
There are 2 weeks of early voting though.
No, I volunteer at the polls. I could find someone to sit in for me, obviously, so it's not a major issue, but
Okay.
I just wanted to put that out there.
I appreciate that, but considering all of the early voting opportunities, including weekend voting, I don't know that I'm gonna cancel court for a day. I really would like for us to move as expeditiously as possible through this case. I don't think we want to be here this time next year doing the same thing.
I'm never one to argue against that, Your Honor. On that,
Sure.
my office should have sent your honorable court an email about, I believe it's the same day, November 5 is election day. I was given the honor of arguing a case before the Honorable Supreme Court of Georgia, Georgia State University that morning. So I have to clear it with your honorable court, but I just want to, I have to let the court know.
Okay. I'll let y'all know. I haven't seen that email yet, but I'm sure it will get forwarded.
sent to Ms. Percival, but we could, and Ms. Ross.
I'm sure that they'll send it on to me. You may. Yes. Oh, it's fine. I just was sending out the Zoom link on the email that your, I guess, assistant had sent. It's fine. I don't need to know. I appreciate it though.
I believe that we were awaiting a transcript, and if I got that this weekend, my apologies to the court because I was under the weather this weekend and I did not see the portion of the transcript that reflected exactly what it was that I said in response to a particular.
Then the transcript that I think Miss Percival forwarded on Sunday afternoon. I can read it out.
I haven't.
It's pretty close to what my memory of it was actually. You say, Your Honor, but there is a difference that matters. It's a distinction with a difference because what Mr. Steele was putting up is a picture of Defendant Williams with a young man whom evidence has come out did not associate with Defendant Williams after a particular time. So can you point the court and defense counsel to the portions, and I know we don't have Detective Dennis's transcript yet, but we have the transcript from Mr. Donovan Sr. You should have gotten that forwarded from Ms. Weaver. Have you had an opportunity to look at it yet? Okay.
And while we are looking for more specific language, I just want to point out to the court that to the extent that the objection is made that there was a comment on the evidence or the evidence saying a particular thing, two things as it relates to what I said. I intentionally did not speak a particular name for multiple reasons. And I was particularly vague for multiple reasons. But the objection that I had was that Mr. Steele asserted through his language that that particular flyer was introduced in 2015 and that
Right.
and Mr. Sledge agreed with that. And Mr. Steele then put forth a flyer that he said would have chronologically come after that flyer that I had the objection to. And that flyer that he put up was one from December 2014. So this is not a circumstance where I testified, I alluded to, I made reference to something that I believe existed. I did not comment on, you know, what that evidence was or make a comment on the evidence. But unlike a circumstance where a lawyer would say, you know, that didn't happen to a question being asked, I simply said the evidence, there's been evidence. I didn't say what evidence, I didn't comment on a particular piece of evidence. And so in as much as my statement to the court was intended to orient the court and to apprise the court of why I was making the objection without speaking too much about it, I would ask the court to overrule Mr. Steele's objection to my objection and deny any motion that he made as a result of it. But we are still at the court's direction looking for the language that led us to be where, led me to make the statement that I made.
Understood. And Mr. Steele, looking back, and you, when we were talking about it Friday, you said you weren't sure that you had said 2015, but looking back on page 10 before the objection by Ms. Love, you do say 20, I mean, you don't say, but you're asking, is that 2015? And the witness agrees, and apparently everybody knew it was 2014. So,
May I speak?
sure.
So I agree, I misspoke. But yeah. My issue, reason, and thank you for allowing. Appreciate you allowing that to happen and that it's still preserved. My issue though is this. I definitely misspoke. I watched the long order or whatever, long cry. And then I got the transcript later. And I apologize. All it has to be said is, where's the date on it? Ms. Love said that, or are you certain, or do it on redirect? And then I corrected because I said this is in date order. And then I went back to the next flyer. Is it the same band, same group performing? And it's December 31, 2014, going into January 1, 2015. I wanted to correct it. I didn't realize at the time I said 15, it just, I wasn't focused properly, I guess. But for a lawyer to then say, and the evidence has shown, that was my issue.
Yeah, I understand what your motion addresses.
And this is easy to figure out because I can't get these Twitters anymore. They're gone. They won't. I tried to subpoena them. I can't get them. But the state, through Agent Racy, he's a cop. He's now with ATF, but he was with Cobb County. He got just, I don't know why, but just a certain amount of time from middle of 2014 to the middle of 2015. Got a year. All these are dated. The reason that these aren't dated, I put in, is because previously the state had an objection to any writing on it, but everybody has the date. It was December 26, 2014 and December 31 going to January 1, 2014, 15. But my problem is we can't be making any lawyer what the evidence is until a closing argument, and the evidence is not closed yet. So that's my big problem. And I will say this. The state gave us an email. If they don't remember it, I could put in evidence for it, just for the record. On Friday, August 9th, 2024, at 5:22 p.m., your honorable court is CC'd through the Honorable Miss Persifield, and it gives the list of people testifying. That's wrong. That's the wrong date. I gave the wrong date. I'm looking at the wrong date. I'm sorry. This was given the way it used to happen. I don't know if it still is, but Miss Hilton would give a list every Friday to the media and then to us of who the next witnesses are, and certain witnesses, for whatever reason, couldn't be shown.
Right.
So they were undercover agent or something like that. And then there were objections there too. But on the media list of 5/10/24, so it's May 10, 2024, the state had Detective Racy, which is RAISSI, by the way. He's now Agent Racy. And then followed by this performer, Mr. Lamar. His first name is DEQUANTES. And he goes by Rich Homie Kwan. And that came to everyone via email from Ms. Hilton. That's May 2024. So my point is, the state had him on a short list. They didn't call him. They don't have to call witnesses. I get that. So I was going to call him. He's already under subpoena. And I assume the state knows this because they didn't call him. But on March 23rd, 2015, Mr. Lamar, or Rich Homie Kwan, and this is all public, he said, I'm still affiliated with Rich Gang, with them, talking about Rich Gang. In an interview that was with Thesis, THISIS50, in an interview with ESPN on April 20th, 2015. And 2015 is right after the January 2015 death of Mr. Thomas. Mr. Lamar reaffirms that Mr. Williams will always be his, and I'm quoting, his brother. And with Vlad, VLAD TV, Mr. Lamar talks about Mr. Williams on April 21, 2015, wishing Mr. Williams the best. In an interview, he states that he and Jeffrey have no, excuse me, Mr. Williams have no, quote, bad blood. That's May 16, 2022. September 18, 2022. He talks about that they get along. An interview with Cam Newton, August 15, 2022. He details how he's a fan of Mr. Williams' work even before they met, and he emphasizes that he and Mr. Williams never had a problem. And it goes on. He has other interviews here. The point I'm trying to make is, I contest that there was this supposed eruption, and they don't get along. So the state put up Mr. Donovan Thomas Sr., they said last week to the Honorable Court, to make this claim. They don't put up the actual people involved, and I'm going to put up, if I need to, I know I don't have to put up a case, but if I need to, I'm going to put up people who observed the two of them together. The people who interviewed him, I know I'm going to get objections to hearsay, but the point I'm trying to make is, to say that I said the wrong date doesn't need this additional. That falls on the exact same platform as it, with the same witness last week. District Attorney Love read a plea colloquy in an unrelated Alford plea. I don't know how that happened. That's from Mr. Sledge. And then I believe, and it's not a violation because I try to speak with every witness. If they won't speak, that's fine. But at that June 9, 2024 meeting at Starbucks in Fayetteville, there was clearly Brady evidence. Now, some of it was given to us. The Brady evidence that was given was what I originally said. It was August 9, 2024.
So, Your Honor, if we could deal with one issue at a time, I don't have any problem addressing each of them. I would ask the court's indulgence to allow me to address each one in turn because I've heard about 4 so far. And we're on to Brady evidence at Mr. Sledge's interview, which is entirely different than the exhibit Mr. Steele put up that we were addressing.
All right, well, we were trying to give you time to find the portion of the testimony to support what you said on Friday. I think Mr. Steele's just
If
outlining what his other issues are going to be.
Because I'm going to have to address each of those, and I do have a response to each of those, I was trying to listen and to take note.
All right, we have 2 other people sitting at council table with you. I'm sure they're equally capable of running a word search and a transcript. Go ahead, Mr. Steele.
It's just that, at this meeting, it comes out that Jeffrey Williams is with Mr. Donovan Thomas days before he's killed, according to Mr. Sledge. I have other evidence that puts them together, but that's a contested part. It's not really Rich Homie Quan, it's Mr. Thomas, Donovan Thomas. And what the state's trying to say is that, for the court's edification, I believe is what they're saying. Mr. Thomas is trying to be the manager of Rich Homie Quan. Mr. Thomas doesn't want Rich Homie Quan to sign with a man named Mr. Brian Williams, who's Birdman. Jeffrey Williams is not signed with Brian Williams, Birdman. Somehow Jeffrey Williams doesn't like the fact that Donovan Thomas won't let Rich Homie Quan sign with an independent person. So Jeffrey Williams has him killed. The jurors may adopt that. But when Mr. Sledge tells District Attorney Love on June 9, 2024, that Jeffrey Williams and Donovan Thomas were outside, and I thought it was TIG, but T.I.'s studio. He's a wonderful performer named Clifford Harris in Atlanta. And they're having a good time. That's Brady evidence. And I never got that. Now I did get it. I don't want to, there's no violation. I'm making it clear. I got it from Mr. Sledge and Mr. Wright. But we should have gotten it from the DA as well, because they didn't know. I assume they didn't know that I got it from other people, and I don't think Mr. Matthews got it. I didn't share it with him anyway, so that's Brady evidence for him too, because it's part of the state's case. Those are my issues. It just, that's one witness last week, and it's the objection, it's the Brady, and it's the reading of a transcript. It's just a lot to deal with. That's it. My objection to do. So those are my issues.
All right, thank you.
And I do apologize for the speaking, and hopefully I cleared it up.
I mean, it happens. I don't find any purposeful action on your part in saying the wrong year. But
Thank you, Your Honor, for allowing me the opportunity to speak. I apologize to the court in advance. My voice is a little lacking today, but as we are bringing up things and patterns, I want to bring to the court's attention a couple of things that the court would not have knowledge of, as the court could not have been present when it occurred. I've read the portion of the transcript where I said, as it relates to a young man in the picture, I believe evidence has come out that, and I want to read it exactly as I said.
well, I mean, I already read it out once.
Mr. Steele was putting up is a picture of a defendant Williams with a young man whom evidence has come out did not associate with defendant Williams after a particular time. So there have been instances during this trial with other witnesses, much like the way that Mr. Steele is alluding to instances that the state has brought up. I'm bringing this up for a reason, if the court would give me indulgence, where the state has asked a witness a question. For instance, did Mr. Steele ask you to, did Mr. Steele stop the recording while you were talking? And Mr. Steele literally verbally stood up and said, that didn't happen. That did not happen. While the, see right there. And so giving testimony during trial, I did make an objection to that. That was addressed. That, in my estimation, is wholly different. And that is the kind of thing that it would appear Mr. Steele is sort of alluding to the state having done now, and it's not. I did not state anything about the weight of the evidence. I said vaguely as I could, I believe this has come out. The jury will know. My objection was intended to inform the court as to why I made that objection. I will point the court's attention, since Mr. Steele has brought up these interviews he's talking about, to the discovery we did provide.
You know what? He admits there's not a violation. So have you found the portion of the transcript that you say support?
Name a person.
I understand, but then you said to me
I did.
afterwards, outside the presence of the jury, I've got a basis for saying that.
And I did.
Okay.
During the examination of Donovan Thomas Sr. by Ms. Hilton, she asked whether or not Mr. Thomas Sr. ever saw this person, this gentleman that I was referring to,
Mm-hmm.
and defendant Williams perform again after December 2014.
Okay.
He said no. That was the evidence. That is the reason that I said that evidence has come out that these people didn't associate after a particular time. I intentionally did not want to speak on 2015, 2014, but I can state in my place that unlike interviews and all of that, we've had interviews by people other than counsel in the courtroom. We've actually had interviews where we have had investigators told that after the murder of Donovan Thomas, that this gentleman and defendant Williams did not speak again, period. After they saw each other in Miami following the murder of Donovan Thomas Jr., a question was asked, where is Woody? Defendant Williams told this person, Woody was in Atlanta. This person looked over and saw Woody on a turntable or something in that same club, and this person walked away and did not say another word to him afterwards. The point that I'm making is that when I see an assertion by counsel that there has been something, a concert by the two of them in December 2015, and the statement wasn't made, it's a leading question, so it's essentially a statement wasn't made once, it was made more than once. And then the witness adopted it and said, yeah, it was in 2015.
All right, so
I don't
I
know
think
any other
I
way to
see the
correct.
portion of the transcript that you might be referencing. It is on page 45 of the rough of Mr. Donovan Thomas Sr.'s testimony. There's a question about a video shoot in Birdman. After this video shoot, to your knowledge, did your son ever promote anything dealing with Jeffrey Williams? The answer, after the Fulton Industrial video shoot, no. Is that what you're talking about? Or is it something else? Because it would be nice if y'all could point me to the part of the transcript. But you know what? Regardless, I think that the issue and the reason that Mr. Steele made the motion is because you said in front of the jury, and I hear you saying Mr. Steele did the same thing, which honestly, y'all, neither of you, that if it is improper, the fact that the other person is doing it doesn't make it less improper. Two wrongs don't make a right. Y'all are familiar with that. But I understand that you were trying to correct the misstatement about the date and essentially say, you know, it's not possible. The better way to have done that would probably have been to say, can we approach and call to Mr. Steele and the court's attention why it is that what he was saying about 2015 wasn't possible. So I don't think that it is anything that is serious enough to warrant a mistrial. But for both of y'all, for everybody, if something like that comes out and you think for whatever reason that something is getting misstated by the attorney, just ask to approach and we'll deal with it up at the bench, okay?
Your Honor, there is a,
Can I get everybody's okay on that?
absolutely.
All right, great. Go ahead.
Thank you. There is an issue that I have experienced. I have made an objection, and when I hear an objection, if the objection is made to my question, I pause.
Yeah.
But that does not happen. And so if when I object, a person continues to talk and improper information is being put before the jury, I don't know what else to do.
Okay. I'll address that. So I noticed that as well. Everybody, when you hear the word objection, stop talking and let me hear what the objection is. And then sometimes I will still need to hear the entirety of the question because I won't know whether the objection is meritorious or not because I'll need to hear the rest of the question. But not always. So just stop what you're saying. Let me hear the objection. And then if I need you to tell me the whole rest of the question or whatever it was you were saying, I will let you know that. And then you can, and then I'll make a ruling. Can we operate like that from now on as well? Great. Okay. We ready for the jury now? You need a minute? Yeah. Okay. Sure. We'll take just a minute. Yes, just, we're early on, but does anybody else need to step out? Do we need, like, with regard to the defendants? Yes? Okay. Everybody go to the bathroom. Come back, let's get going.
Tomorrow's a brand new day. Tomorrow's a brand new day. Tomorrow's a brand new day.
Go beyond with East Tennessee State University's online MBA programs, from enrolled to employed. An ETSU online MBA provides affordable, high-quality education, preparing you for success in today's job market. At East Tennessee State University, you can break the mold, defy the odds, and go beyond. Go beyond. Learn more at onlinedegrees.etsu.edu.
believe, I'm not sure.
Okay, that's fine. Good morning, Mr. Sledge. All right, thank you very much. Good morning, ladies and gentlemen. I hope you all had a very nice weekend. Mr. Steele, I believe you were finishing up your examination of this witness.
Yeah, may I approach Mr. Sledge?
You may.
Mr. Sledge, may I approach you?
Yes, sir.
I'm showing you what I've marked as Mr. Williams or JW 255. You take a peek at this for me, tell me whether you recognize that item.
Yes.
And is it in the same condition? Have you seen it prior to, 2024, 2023, going back? Is it the same condition?
Yes.
Any alterations or changes to it that you can tell?
No, not
Your Honor, I move for the admission of Mr. Williams 255.
It's admitted.
May Mr. Kokomo display it, Your Honor?
Yes.
It should come up on your screen, but it should be the same exact thing. You can check it. That's in front of you, okay?
Yes.
And if Mr. Kokomo can blow that up at all, and if not, that's fine. So this is exhibit number at the very top, Mr. Kokomo, if you just show, you see where it says exhibit or EXH number JW, Jeffrey Williams 253. I believe it's 255, but. Let me see if I can. You see at the very top, 255?
Yes.
Okay, and then if Mr. Kokomo can just center so all the words can be seen on the actual writing. Do you recognize this as a social media posting? And do you see the date?
Yes.
And it's from DMAC, got me to TOO, banging at DMAC, to banging. You see it says December 27, 2014.
Yes.
And does it read then, and I'm changing it just because that's how I am, A-N, lie to their mama, brother, sister, and kids, but get to the courtroom and tell the God's honest truth, 3 question marks. I don't get it. And then hyphen at Young Thug. Do you see that?
Yes.
All right, did I read that fairly accurate? I know it wasn't perfectly accurate, but fairly accurate.
Yes.
All right. And is that similar to what has been marked and played in states number 447Y, where you started out with, I'm going, and this may not be exact, but something like, I'm going to swear to tell the truth, I'm going to lie on God. Remember that?
Yes.
All right. Can you tell the jurors what it means, if you know, when it says at the end of it, the hyphen at Young Thug?
Before it,
Can
I
you,
don't,
can you explain that to the jury?
I don't get it.
Yeah, right after that.
At Young Thug. I'm at Young Thug. I'm sorry.
Yes, do you see that?
Yes.
Do you know, and if you don't know, just say, I'm not sure. Do you know what that means?
No, I don't
That's
know
fine.
exactly what it means.
Okay, and this one goes back, if you remember, and if you don't, we can show it to you. But do you remember what the state used on January 26, 2015, said repost? You remember that?
The repost was
Yes.
yes.
Okay, and then you showed the jury the January 4th, 2015 video, same video, Jeffrey Williams, you remember that?
Yes.
And this one is approximately a week before January 4th, 2015, right?
Yes.
December 27, 2014.
Yes.
And prior to this, prior to 2014 and 2013, 12, going back, have you heard this same type of statement?
Yes.
All right. Now, did anyone from the police department or the district attorney's office, and I'm saying after you entered a plea, so this is December 28th, 2022, okay?
Yes.
After that, so coming forward.
Yes.
Did anyone from the district attorney's office or one of their teammates, police, whomever, did they ever ask you?
Objection. Relevance as to what anyone else ever asked this witness. If Mr. Steele wants to ask something, he can.
Ask about the evidence of the reposting? They showed the gentleman the evidence?
Your Honor, my
Know if
objection.
anybody- I want to know if anybody ever went over with him that it's a repost.
Your Honor,
Sustained.
Did at your meeting, we'll just do it on June 9th, 2024 at the Fayetteville Starbucks.
Yes.
Did District Attorney Love ever ask
Objection.
you about,
objection. Yes.
Sustained.
did State's Exhibit number 447Y, the repost, January 26, 2015, was that ever discussed with you?
Objection, Your Honor.
Sustained.
Where it says on the January 4th, 2015 video, and if you need to see it, I'll show it to you. Do you know what I'm talking about?
Yes.
Okay, where you read to the jurors that Mr. Martinez or Duke said it first?
Yes.
Remember that? Okay. Did you ever explain to anyone about Mr.
Objection, Your
Martinez
Honor.
saying it
That would be
first?
hearsay.
He's right here.
Explaining outside the court, it would be relevance and objection.
Sustained.
Now, District Attorney Love asked you on your direct examination why you didn't go to the police on the morning of January 11, 2015, when you dropped off Mr. Copeland at the City of Atlanta Police Department homicide. Do you remember that question?
Yes.
All right. And you were aware that the police called Mr. Copeland that
Yes.
night, and then Mr. Copeland went down to see the police, right?
Yes.
Did the police call you and tell you that you were the prime suspect?
No.
Objection to the compound question.
Overruled.
No.
You were asked questions about the music company or business YSL, direct deposits. You remember that, working for them,
Yes.
working for Mr. Williams? Remember all those questions?
Yes.
All right. Do you personally know, do you personally observe, does that music business have lawyers working for them? If you know, if you don't know, just say I don't know.
I don't know.
All right. Do they have accountants?
Yes, I think they have a calendar. I know that.
How about managers?
Yes.
Objection, Your Honor, vague as to managers.
Overruled.
Yes.
Now, you were asked a lot of questions also about what you explained to the jury, that anybody can claim YSL. You remember all those questions?
Yes.
There was no beating in, there was no initiation. Do you remember those type of issues?
No. Never had that. You never have to get beat in or however.
Somebody could just say I'm with YSL.
Right.
By doing that, does that mean that they're with the record company YSL?
Objection vague by doing that.
Now, you mentioned yesterday meeting with Jeffrey and Mr. Brian Birdman Williams and yourself and Mr. Donovan Thomas and others, I'm not excluding others, shortly before, God forbid, Mr. Thomas was, days before he was killed on January 10th, 2015 at TI Studios. You remember that testimony?
Yes.
Is TI the performer TI that you're talking about?
Yes.
Do you know his real name?
Some Harris. That's all I know. I know his last name Harris.
Mr. Harris?
Yes.
And is he a phenomenal, well-known, accomplished artist?
Objection.
You were asked about the definition of snitching. Do you remember that?
I don't remember asking me that.
All right. Do you remember saying in the video 447Y snitching, and I'm not gonna say, but BIT blank 8?
Yes.
Okay. And tell the jury what snitching means.
To me, my definition of snitching is another person lying on another person.
Now, on from December 28th, 2022, I'm using that date because that's the date that you were released from custody on this case. That's the date of your guilty plea, okay?
Yes.
All the way through today, but including Sunday, June 9th, 2024, when you met at the Fayetteville Starbucks?
Yes.
The district attorney and your lawyer and the investigator. Did anybody go over with you what's been gone over with you in court, the plea agreement?
No.
You told the jury that Jeffrey idolizes Lil Wayne or Mr. Dwayne Carter. Do you remember that testimony?
Yes.
Did you ever hear, are you familiar with Lil Wayne's work? His music, his
Yeah, I'm familiar with his music.
Have you ever heard him use the word slime, the term slime?
Yes.
Was that before you ever heard anyone say it, or was it after?
I hadn't heard it said before, but he's like one of the first artists I heard say it.
He being who?
Lil Wayne.
Your Honor, I don't have any other questions.
All right, Ms. Weinstein, you had brief cross.
Thank you, Your Honor.
Brad.
Good morning, Mr. Sledge.
Good morning.
My name is Doug Weinstein, and I'm Diamante Kendrick's attorney.
Yes.
May I approach you and show you something?
Yes.
Thank you. I'd like you to just take a look at this video. Do you recognize the action that was performed by that player?
Yes, Tyrone here.
Testimony about it.
Oh, I'm sorry.
Excuse me, just do you recognize that
Yes.
player?
Yes.
Do you recognize the action that he performed?
Yes.
Okay. Your Honor, I'm moving to admit Kendrick 1.
I object on the basis of relevance and foundation, and if we need to approach so that Mr. Weinstein can show the court what it
Well,
is.
Yeah, I haven't seen it, so.
Okay.
Giving out our.
I need to step out. Okay.
It's got an NFL offer.
Don't play with me.
Then we'll take it.
Aren't you a little too old to be playing football?
Wait, what?
They want somebody that can run a 40, not somebody that is 40. When the coach calls your number, you gonna say G56. Bingo. How you gonna sell them?
sustain on the foundation, but you can see if you can lay further foundation.
Thank you, Your Honor. Mr. Sledge, I have a few more questions about that video that I showed you.
Yes,
Have you seen that video of that player before?
I know who the player are.
Have you seen him doing this particular thing? Have you seen that clip before that I showed you?
I don't recall seeing the clip, but I just seen it when you just showed it to me.
Did you watch the game yesterday?
I didn't watch Miami game yesterday.
Okay, I'll move on.
All right.
I'm going to show you something else, all right?
Yes.
May I approach?
You may.
You see this photograph?
Yes.
Have you seen that photograph before?
No, not to today.
Okay. And I will not be asking you questions about that photograph.
Right.
December 28th, 2022, going back to that date, where did you wake up in the morning?
At Forest County Jail.
And where did you wake up on January 1st, 2023, New Year's Day?
And at home.
At your home,
Yes.
in your own bed.
Yes.
And you signed that plea deal that we've already talked about.
Yes.
And you initialed all those statements that were made in there, right?
Yes.
And you would have initialed anything to get out of jail on that day, correct?
Yes.
If they would have asked you if you could say that YSL did
Objection
not kill
calls for
Tupac,
speculation.
What's the question?
if they had asked you,
Objection
If
to
you-
if they had asked you, just nothing else beyond that, Your Honor, because it's speculation stage.
but again, you signed and initialed all of that, and you would have signed and initialed anything to
Objection.
get out of Rice Street,
Asked,
correct?
asked and answered.
No more questions.
All right. I think nobody else had cross, is that right? Is that still the case? Okay, all right, is there redirect?
There is, Your Honor.
All right.
Mr. Sledge, you were asked quite a few things by Mr. Steele on Friday regarding what was and what was not asked of you at the time that you entered your plea agreement with the state. Do you recall that?
Yes.
Your Honor, just
Yes.
To satisfy the rule of completeness, the state tenders State's Exhibit 444Y, the entire plea agreement, or State's 1AS, which was admitted for a different purpose at a
All
different
right,
time.
any objection? Okay,
Your Honor, I would object to further commentary unless we need to approach. I'm tendering the exhibit.
I understand. He's not commenting. He's stating what his objection is because I asked him to. I think we might need to approach to resolve it though. Let's get Mr. Sledge back, please.
Thank you, Judge.
All right, go ahead, Ms. Lowe.
Thank you, Your Honor. Mr. Sledge, on cross-examination just now, I believe it was by Mr. Weinstein, forgive me if it was by someone else. Were you asked the question whether anyone ever went over the plea agreement with you between December 28, 2022, when you signed the document that is states 444Y and states 18S, and today? Were you asked that question on cross-examination by either Mr. Steele or Mr. Weinstein?
I don't know. I don't think Mr. Steele asked me that. He asked me something about June the 9th. So I don't know if Weinstein just asked me that question.
All right. Did Mr. Steele ask you on cross-examination whether anyone went over that document that you signed on December 28, 2022 with you at the June 2024, I believe it was, meeting between you, your attorney, Investigator Lancico, and me in Fayette County? Did Mr. Steele ask you that?
I think that was the question. Was.
And was your answer no?
Yeah, no, yes.
At that point, had the document already been signed in its entirety? Had you already signed everything you needed to sign?
Yes.
On cross-examination last week, you were asked about hiring an attorney for the purposes of this case. And let me actually back up and ask you this. You were asked a few questions about what was going on at the time that you signed this plea agreement on December 28th, 2022. Do you recall that?
Yes.
All right. Do you recall being in a courtroom here in Fulton County on the date that you signed that plea agreement on December 28th, 2022?
I don't think I was in the courtroom. I think I was in the tank in the back when I signed.
Okay. Were you in a courtroom when you acknowledged under oath that everything that you signed was true?
Yes.
Did Mr. Steele, Mr. Sharp, or any of your other friends' attorneys ask you on cross-examination?
Sustained.
Okay. Did you tell the jury that you loved Mr. Stillwell? You loved Shannon?
Yes.
Did you tell the jury that you loved Defendant Williams?
Yes.
And Mr. Stillwell and Mr. Sharp and Mr. Williams, they represent people that you love, correct?
Yes.
All right. So on cross-examination by lawyers for one of the people that you love in this courtroom, were you asked about your conditions prior to signing the plea agreement that you signed on December 28th, 2022?
Could you repeat that?
Yes. On cross-examination last week, do you recall being asked about conditions you endured before signing the plea agreement that you signed on December 28th, 2022?
Yes.
Do you recall being asked if you felt pressure to sign that plea agreement?
Yes, I think so.
Do you recall being asked whether you felt intimidated to sign that plea agreement?
I don't recall that.
I'll ask you, were you intimidated by the state into signing that plea agreement?
Was I intimidated?
Were you intimidated?
I wouldn't say I was intimidated. I was basically like, I just feel like it was forced on me at the time. I wasn't intimidated by it.
It was forced on you. We're going to come back to that word force, okay?
Yes.
Do you recall on direct examination when I was asking you questions, do you recall you first mentioning something about the fact that your mom, unfortunately, had become ill? Do you remember that?
Yes.
Do you recall telling me not to speak on her?
I said I didn't want to talk about her.
Do you recall Mr. Steele asking you about her multiple times?
Yes.
Did you have any problem with him talking about her?
No, because me and my lawyer had discussed, don't even get frustrated about it.
So is your testimony that you want in particular to sign anything on December 28th, 2022?
I'll say the state because when I addressed it and tried to change situations, they wouldn't change them. So,
And it's still your testimony. Is it still your testimony that there were things that you wanted changed that you did not get changed? Is that still your testimony?
Objection asked and answered.
Overruled.
could you repeat it?
Is it still your testimony that there were things you wanted changed in this plea agreement that you did not get changed?
Judge, Your Honor, could I talk to my lawyer right fast?
You may.
Okay.
All right, let's just take a recess. I know we just broke, but if anybody needs to use the restroom, you can go ahead and do that. And can somebody let me know when he's back from talking to his lawyer? Thank you. Yes, Judge.
Building your online business? Go to Wix.com and set up your store on a single integrated platform.
That's never any fun. Thank you. Go ahead, Ms. Love.
Thank you. Mr. Sledge, have you had enough time to speak with your attorney?
Yes,
During the time that you spoke with your attorney, is your attorney the only person that you spoke with?
yes.
All right. Did you speak with any member of the state this weekend?
This weekend?
Yes.
No.
Did you have an opportunity to speak with your attorney this weekend?
Ma'am didn't talk, but
Okay. All right. So did you testify on cross-examination last week that there were portions of the plea agreement that you signed that you asked the state to change, but that the state refused to change?
no, what I said, yes, but they changed certain things, but it still was things that I had problem with. From my awareness, once if you call me to the stand, then I would be able to explain the things that they didn't change.
Do you recall when I first asked you questions on direct about the April 2015 drive-by shooting that you, the April 28th, 2015 drive-by shooting? Do you recall when I asked you about that on direct?
Yes,
Do you recall you told me you did that in your best interest?
could you repeat that? You lost me right now.
Do you remember saying that was in my best interest when I asked you if you pled guilty to the shooting on April 28, 2015?
Yes,
And do you remember saying that I did that because it was in my best interest multiple times? Do you remember saying that?
you said that I took the plea in my best interest.
My question is, do you remember?
I don't recall.
Mr. Sledge,
Okay.
do you remember us talking about your 2015, April 28, 2015 shooting and that subsequent plea last week? You and me, not anybody else, while you've been on the stand.
You said the 28th drive-by shoot?
Yes, sir.
Yes,
All right. And do you remember I asked you whether you pled guilty to that? Do you remember that?
yes,
And do you remember you told the jury, do you remember telling the jury, well, I did it in my best interest? And
Yes.
this is not a trick question, I promise you.
yes.
All right. And do you remember you said that more than once? I did that in my best interest.
Yeah, I remember that part.
And when you say in your best interest, are you familiar with what is known as an Alford plea?
No, I don't really know what an Alford plea really mean. I just was saying that I pleaded guilty in my best interest.
And when you say that you pleaded guilty in your best interest, what do you understand that to mean as opposed to just flat out pleading guilty?
Could you repeat it?
I can.
Cause that was kind of tricky.
So if you enter just a regular old guilty plea and someone asks you, did you plead guilty? Would it be unusual for you to just say yes? I pled guilty?
Anything I plead guilty to, I feel like it's in my best interest to plead guilty to.
That plea that you entered in 2017, especially, there was a special designation to it though, right? It was an Alford plea, wasn't it?
I didn't know it was an Alford plea.
When you entered the plea that you entered on December the 28th, 2022, did you recognize the prosecutor asking you questions as the same one talking to you here right now, me?
Yes.
All right. And did you recognize the prosecutor at the table with me as the same one I have my left hand on now, Ms. Hilton?
She wasn't in the courtroom when you did the plea. She went somewhere.
Okay. All right. So we see the video, but we see Ms. Hilton's lovely face. You'll recognize Ms. Hilton as having been in the courtroom?
I don't remember seeing Ms. Hilton.
That's fair enough. Do you remember seeing a judge who looked a little different than the one on the stand now?
Yes.
Okay. Do you remember seeing your attorney, Mr. Wright, there sitting with you?
Yes.
Is that the same attorney that you had in 2015?
I don't think I got arrested in 2015, but if I would, he would have been the one to do the case.
Did you testify on direct examination that Mr. Wright has been your attorney for 15 years?
Yes.
Could you tell the jury when Mr. Wright first started representing you in criminal matters?
I want to say like 08, 09, something like that, if I'm not mistaken.
Did you tell the jury on cross-examination that Mr. Wright is someone that you trust?
Yes.
Did you tell the jury on cross-examination that Mr. Wright is someone whose advice and counsel you take seriously?
I don't remember saying like that. You put it in that word.
Would you just tell the jury right now then how it is you feel about the lawyer who's represented you for the last 15 years?
He been great. He been great to me.
Okay. And he was in the room with you when you entered the plea on December 28, 2022?
Yes.
Is this the first time you've had to testify at a criminal trial?
I don't understand what you're saying.
Do you understand that you are now in a witness box testifying in a criminal trial under oath?
This is my first time knowing that I was a witness to testify up on the oath.
All right. So this is the first time that you've testified in a criminal trial. Is that fair to say?
I ain't gonna say it's probably not my first time, but me knowing that I was gonna be called as a witness, yeah, this is my first time.
All right. Do you remember being asked on cross-examination by either Mr. Sharp or Mr. Steele? I believe it was Mr. Sharp, your friend Shannon's lawyer, whether you
Oh, I think she's just trying to get clear who it is. We don't need the commentary.
Yes, Your Honor. Do you know who represents your friend Shannon?
Yes, I've been sitting in the courtroom like everyone else.
Which person do you recognize as representing defendant Stillwell?
Mr. Short.
All right. So do you remember Mr. Sharp asking you if on December 28, 2022, you found yourself between a rock and a hard place?
Yes.
And what did you answer to him regarding December 28, 2022?
What did I say?
Yeah, what was your answer to that
I
question?
said yes.
And would you tell the jury what the rock was and what the hard place was?
The rock was the situation I was in, and the hard place where my mother was sick.
And when you say the situation you were in?
Incarcerated.
Okay.
And
all right. And hopefully, is your mom doing,
no, she deceased.
I'm sorry. So did your being in Fulton County Jail have any bearing on your decision to enter that plea that you entered on December 28, 2022?
Being in Fulton County Jail and away from my mother.
All right. Which one had the biggest bearing?
Being away from my mother.
All right. So being in Fulton County Jail wasn't a big factor in your entering that plea?
Objection, mischaracterized this as
I'm asking a
testimony.
question.
I didn't hear them both at the same time, so.
I'll rephrase.
All right, she's gonna rephrase.
Mr. Sledge, was being confined in the Fulton County Jail a large factor in your deciding to enter a guilty plea on December 28, 2022?
Yes, it was, but my mother was bigger.
Is there any reason why during the plea colloquy that the jury heard on Friday, that was played Monday, last Friday actually, that was played at the end of the state's direct, is there any reason, or rather let me ask you, did you ever hold up your hand and tell the court you wanted to make some clarifications?
No, I would have directed it to my lawyer, and whatever you did, but what I wanted, you wouldn't do. You didn't do everything I wanted, which I state.
You were asked by Mr. Steele, your friend, Mr. Williams' attorney, whether or not the state ever sat down and met with you. Do you remember being asked whether the state ever sat down before the June meeting and before you entered that plea agreement and met with you? Do you remember him asking you that?
Yes.
Did the state ever sit down and meet with you?
No.
Did you ever agree to sit down and meet with the state?
I can't agree if the state don't come to me and ask me.
Do you, or has your attorney, or do you have any understanding that the state can't come to you except through your attorney?
No, I didn't know that.
Did you ever have an understanding that the state wanted to talk to you before you signed the plea agreement on December 28, 2022?
No.
Did you ever ask your attorney for an opportunity to speak with the state?
No, I never asked him to speak to the state.
Why not?
I don't know. I can't tell you that else. I never asked him to speak with you because that's his job. That ain't my job. That's why I hired him.
Was there anything about the state that made you feel you couldn't speak with the state if you wanted to?
No, but if they would have came to me and asked me to speak with them, with that plea agreement was on there, I would have told them the same thing I told him when I took it. Like, that ain't right.
Now, when we speak about the state, is your understanding that that means only the district?
It's got an NFL offer.
Don't play with me.
Then we'll take it.
NFL. Aren't you a little too old to be playing football?
Wait, what?
They want somebody that can run a 40, not somebody that is 40.
New customers score this great offer and a month of NFL Plus Premium.
Did you consider them the state as well?
I don't know. I think y'all work in two different departments.
You're right.
Because I don't see the state on the street locking people up. The police, I do.
Okay. So when you spoke with the police back in 2015, did you tell the police any of those things that you told your friend, Defendant Williams' attorney, and your friend, Defendant Stillwell's attorney, when they asked you questions on cross? Did you tell the police any of that stuff?
I don't think they asked me nothing like that. I don't recall them asking me nothing like that. You said the police?
Yes, sir.
I don't recall them asking me nothing like that when Mr. Steele asked me.
Do you recall Mr. Steele asking you about that drive-by shooting?
Oh, yes.
Do you recall the police asking you about that drive-by shooting?
Yes.
How much information did you give the police about that drive-by shooting?
I told the police it wasn't true.
Now, okay, so, and when I asked you on direct examination about that drive-by shooting, what did you tell me about that drive-by shooting?
I don't recall. You can refresh my memory.
Do you recall me asking you what you did before that shooting?
I don't recall it though.
Do you recall me asking you how did that shooting happen? Yes. I can show you. I can respond.
Overruled.
Thank you, Judge. Do you recall me asking you what led to that shooting?
I don't recall.
Do you recall telling me on the stand, or actually telling the jury, because it's not me. Do you recall telling the jury when I asked you on direct that you just went to pick up Mr. Garlington from the club, or that Mr. Garlington had gotten jumped on?
I think I told you I went back and got him from the club. That's what I told you.
And do you recall telling the jury when I asked you questions that you didn't see anybody who jumped on Mr. Garlington?
I told you I didn't know anyone that jumped on Mr. Garlington. The same thing I told them on cross. I didn't know exactly who it was that jumped on me.
Did you tell the jury on direct with questioning by me that you didn't see the faces of anyone who jumped on Mr. Garlington?
Yes.
And did you tell the jury that you didn't see the faces of anyone that you may have interacted with during that time?
Yes, sir.
May I respond?
Yes.
Your Honor, Mr. Steele cross-examined the witness on this very topic. I believe that it is necessary to orient the witness to the questions I asked before I get into the questions that I want to ask him about what he told Mr. Steele, number one. So it's not a 403 waste of time in any way. And I believe that he made a second objection I'd like to respond to, but I can't remember what it was. It was kind of long. And leading, Your Honor, suggests an answer, and it does not consist of questions that simply require yes or no response.
Overruled, and I'll give you a little leeway, but go ahead and get to what you actually want to get to.
Do you recall telling the jury when I asked you about the drive-by shooting that you never saw a shooting?
I don't recall.
Do you recall telling the jury when I asked you about the drive-by shooting that you just dropped off Demekion and Quindarius and you went on your merry way?
I don't think I said I went on my merry way.
You use merry, that's my words.
Okay, but I remember
Just
exactly
went
what you said. I ain't saying I went on and directly left the scene, but I didn't actually witness them shooting the gun. That's what I said.
Is it your testimony today that on direct examination, you did not tell the jury that you dropped off Quindarius Zachary and Demekion Garlington and left and don't know what they did after you left?
I don't recall that.
Do you recall me asking you about another house getting shot up on Drew Drive after the house on Adele getting shot up?
I don't know in what article. I don't know the addresses.
Do you recall me asking you about whether you saw or participated in any other house getting shot up other than the house off MLK on Adele Drive? Do you recall me asking you that?
I don't recall.
So do you not recall as well telling me that you didn't see any house get shot up?
I don't recall me telling you that I seen a house get shot up. I don't recall.
Now, what I just heard you say is, I don't recall
Me telling you that.
You don't recall you telling me what, sir?
I just don't recall, Ms. Lord. I don't recall.
What is it that you don't recall? I'm sorry, I need the jury to know.
I don't recall.
What don't you recall?
I don't recall. I don't recall. You've been pressuring me so much, it's like, I don't even remember a lot of stuff you said.
Is it that you don't recall telling the jury you did not see any houses getting shot up on April 28, 2015?
I don't recall.
Okay, today, do you recall seeing any houses getting shot up on April 28, 2015?
What I'm saying, I didn't see. I'm not saying that I didn't know no shooting was gonna happen, but what I'm saying, I didn't like personally witness the house that you saying that Quindarius Zachary and Garlington shot up. I didn't witness that.
I appreciate that clarification. That's not my question. I'm asking you today to tell this jury whether you recall today see any houses, since it's me talking to you, whether you recall any houses getting shot up. Do you recall seeing any houses getting shot up on April 28, 2015? No.
Overruled. So he just told you about the one house. So are you asking about any others?
Yes, I am.
So ask it that way.
Yeah, you got to tell me directly what house you're talking about, because when he cross-examined me,
That's not what she's asking. She's
Oh, okay.
asking any other houses besides that one.
well, I didn't know. I don't know the people that was shooting at the other house.
Did you see any houses getting shot up? Forget the address. I don't really care what address. Did you see any houses getting shot up on April 28th?
I just don't think that's an appropriate question.
Okay, well, that's not for you to decide. So
Okay,
unless
but
there's an
I'm
objection
saying,
that's sustained, go ahead and answer the question.
Yes.
You did see some houses getting shot up?
Not houses. You now you putting more than one. It was one house that I probably seen.
Okay. Tell the jury what house you probably seen get shot up April 28, 2015.
I think it was Lexi. I don't even think it was a house. It was an apartment. If I'm not mistaken.
Tell the jury what apartment you saw.
I don't know the name of the apartment.
What can you tell the jury about the apartment?
Where I was dropping Quindare, Miss Zachary off at. That's the one I could tell you about.
So, on Friday, when you talked about dropping off Demikion and Quindarius, were you dropping them off at the house off MLK on Adel Drive, or was there a different address you were dropping them off at?
I was drunk, Ms. Love. I don't remember which one it was.
Did your memory come back while you were being asked the same question by Mr. Steele?
No.
Do you remember telling Mr. Steele a whole bunch of stuff about?
I don't think Mr. Steele was the one cross-examining me on that.
Who do you believe was cross-examining?
I think it was Mr. Short, not Mr. Steele.
Okay. Let's go with that for a moment. Do you remember telling Mr. Short then details about houses that you saw getting shot up on April 28, 2015?
I didn't go there.
Your Honor, I object. I object to the speaking portion.
All right, so I think she's asked him, if we need to approach, let's approach.
Your Honor, the court
Let me
heard.
look at. Let's, come on.
Yeah.
Thank you, Judge. Mr. Sledge, please tell the jury what you remember today, everything you remember happening with respect to April 28th, 2015, from the time you picked up Mr. Garlington.
Love, I've been here 4 days, just I don't know how many hours. I can't remember all that stuff, so I don't recall.
She's not asking you now what you remember testifying to. She's just asking you what you remember about that night.
I don't recall.
When did your memory about it leave?
I can't answer that question for you, but
I'm sorry?
I can't answer that question. I don't know.
Did you remember it when you were asked questions by Mr. Sharp? Mr. Sledge, please answer the question.
I don't recall.
You do not recall whether you remembered April 28th when you were asked questions by Mr. Sharp?
I don't recall.
When you were entering the plea agreement that you entered on December 28th, 2022, did you ever stop and ask the judge or tell the judge you wanted to clarify anything?
No, because I thought my lawyer had already did that.
And when you heard the state read out factual acknowledgments and ask you,
Whoever controls the streets controls the city. And I'm here now. I'm gonna be the new kingpin.
indicate part of them are true, but part of them are not.
I didn't think I could speak that in court.
Why did you think you could not speak it in court?
Because I ain't thinking like I could just burst out and say that while the judge reading, or while you was reading out, because the judge didn't read it out. I ain't think I can do that. That was never explained to me.
Between December 28th, 2022 and last week, did someone tell you you could burst out while the state was reading something?
No.
Interrupt?
No.
So last week when I was asking you questions and you told the judge I gave you a headache and made your blood pressure go up, you felt comfortable enough? Did you feel comfortable enough to do that?
Because I'm on the stand trying to explain. When you sit back there, you ain't explaining, but when you sitting on this side, you call me here to tell my truth and my understanding. And that's what I'm giving you. I can't give you nothing else. I'm only giving you my truth.
Okay. And so when you were sitting at the table next to your lawyer, did you feel more or less comfortable about giving your truth?
I don't recall.
Do you want to answer the question?
I just answered.
No, I'm asking you, do you want to answer?
I want to answer any question that you got for me, but if I don't remember, I don't remember.
And so what is it that you don't recall about being at the table with your lawyer?
I just don't recall, my love. I ain't trying to give you a hard time. But it looked like you trying to give me a hard time.
Mr. Sledge, would you tell the jury as between when you were in court on December 28th, 2022, and when you have been in court for the last 4 days, if there is anything different about parties in the courtroom that you can point out?
No.
So everyone here in the courtroom was in the courtroom with you on December 28th, 2022.
When you say
relevance.
Your Honor, it goes to changes.
Okay, overruled.
Could you repeat it?
Were each of the people now in the courtroom today were.
Hang on. Yes. All right, so for the record, that objection is overruled. Let's get the witness back. All right, go ahead, Ms. Love.
Thank you. Just 1 second. Mr. Sledge, would you please tell the jury who is in the courtroom with you today that was not in the courtroom with you on December 28, 2022?
Would you repeat it?
Can you rephrase that? Because that's going to be a whole lot of people. Just get to the point that you want to ask.
Yes. You already said I was here. Was there a court reporter here in the courtroom? Not this one, but a court reporter?
I think so.
Were there deputies?
I think so.
Were there DA investigators?
I think, yes.
Obviously, you said your lawyer was here?
Yes.
All right. Was your friend Shannon here?
If you're trying to get to the point.
Mr. Sledge, I'm not trying to get to anything, and I really do need you to just answer the question.
Listen,
So if you could
But
please, Your Honor, if the court would instruct the witness to answer the question,
Listen to the question and answer the question.
And then you
asked,
can
and
explain.
then you may explain it.
I would ask
Thank
that
you.
he be allowed to complete his answer.
and Your Honor, since his answer was not responsive,
His answer was not responsive.
I'd ask that you
Re-ask the question.
Was your friend, Mr. Stillwell, here in court with you on December 28, 2022?
no,
Was your friend, Defendant Williams, here in court with you on December 28, 2022?
no,
Was your friend, Defendant Kendrick, here in court with you on December 28, 2022?
no,
Was the lawyer for your friend, Mr. Williams, here in court with you on December 28, 2022?
no,
Was the lawyer for your friend, Mr. Stillwell, here in court with you on December 28, 2022?
no,
Was the lawyer for your friend, Mr. Kendrick, here in
Objection.
court with you on December? He
I'm
objected.
saying, why you
Hold on,
running?
Mr.
Relevance to whether I was in attendance at the time he took his plea.
Your Honor,
Overruled.
was the lawyer for your friend, Mr. Kendrick, here in court with you on December 28,
No.
2022? You can answer first and I will let you explain, but I need you to answer
No,
yes or no.
but could you stop yelling at me like I'm your child or something? Not your child.
You are not.
You talking aggressive to me. You don't intimidate me. All them guys over here. So if you would have came to me and asked me
I
to,
want you to be.
well, that's what you acting like. That's what you
Okay.
acting like you trying to
So
find.
do you want me to bring my voice down? And I apologize if
Don't
it
holler at
sounds
me,
like
I
I'm
ain't your
yelling.
child. Can I take a break? No,
Yeah, we've had so many breaks this
Yeah,
morning. We
'cause
really need to get
I'm-
through this.
All right. So, Mr. Sledge, was either Quay that is in the courtroom here today in the courtroom with you on December 28, 2022?
no,
Was Lil Rod in the courtroom with you on December 28, 2022?
get to your point. No,
That is my point.
your point is
Okay.
pointless.
Was the lawyer for Mr. Huey Quay in court with you on December 28, 2022?
No,
Was the lawyer for Cornelius Nichols in court with you on December 28, 2022?
no,
Was the lawyer for Little Rod in court with you on December 28, 2022?
I don't know if that's been asked and answered or not.
It was not.
Okay, well, go ahead if you say it was.
Was the lawyer for
No.
Little Rod
no,
On cross-examination, defendant Stillwell's attorney, Mr. Sharp, asked you about shell kelp and Antrevia. Do you remember that?
I don't recall.
When did you lose recollection of what happened 3 days ago?
I don't recall.
Are all of your answers to every question I ask from now on going to be, I don't recall?
Yes,
Why?
because I don't recall.
And what caused you to lose your memory?
You put so much pressure on my brain, I don't forgot everything. I can't remember all this stuff that been asked to me for the last 4 days. It's like, it's confusing. So I'm not, like you said, I completed the 9th grade. I'm not that intelligent to be remembering all this stuff that you keep asking me. My brain just everywhere. I might need to go see somebody after this court time.
Mr. Sledge, did you have any problem at all understanding the questions asked to you about Brian Steele?
No, God.
Did you lose your memory at any point with Mr. Steele?
He wasn't pressuring me like you. He was helping me. He was explaining to me, he was breaking down. But it seemed like
I appreciate what you're saying. I'm gonna respond to that.
Objection.
Mr.
The witness should be allowed to answer the question.
Were you finished with your answer?
no, she cut me off.
Go ahead.
Go ahead, please.
I said, Mr. Steele was explaining to me, he wasn't pressuring me, but every time it seems like I'm getting up and with you, I'm giving you my truth, and you still trying to pressure me to say something you want me to say when I'm giving you the truth that I know.
Mr. Sledge, do you understand that there's a difference between the way that a prosecutor can ask you questions and the way that a defense attorney can ask you questions?
No.
Do you understand that I cannot lead you when I'm asking you questions?
Sustained.
When you say that there's a difference between the way that Mr. Steele asks you questions and the way that I ask you questions, would you help me understand what that difference is so that I can ask you questions in a way that does not frustrate you?
Oh, well, and he kind of has told you.
She ain't said it. She said you overruled.
Ask your next question.
Yeah.
So will you help me break things down a little bit so that I'm not frustrating you, okay?
You already have.
I understand.
I don't even.
Can we rewind?
No.
All right. When you were asked about Antrevia, was Shell Kell the person you said who had also started a relationship with Antrevia after you?
I don't recall.
What is confrontational about that question?
I just don't recall.
Why don't you recall?
Because you pressured me. I don't recall. You heard my brain.
All right, so let's take an early lunch and you can calm down in the meantime, hopefully, and then we will come back. Let's see, it's almost 11:15. Let's come back at 12:30.
Yes, Your Honor, thank you.
Anything anybody needs to put on the record before we break for lunch? And I sure do. I didn't think about the fact that the trays may or may not be here yet, but they'll be here. in enough time.
Your Honor, may
So-
we be permitted to remain at the table during lunch, or does the court
You-
require that we leave?
What then?
May we remain at the table during lunch, or does the court require that we leave?
No, you can stay here if you want to.
Thank you.
All right, so we're on our lunch recess. See everybody back at 12:30.
together. There is nothing better when you hear it feels like home. Craft together something special with Kraft Natural Cheese. Always made me feel like home.
We've got passion, we've got determination. Like, and if we set our sights on something, you better believe it's happening.
We always felt like our content was all about entertainment and being fun, but there was also this, sort of professional business side. One of the things that we knew was basically essential was getting our own website, so people would actually see a proper official group who mean business and who can deliver. We always had this vision of bringing things into existence that previously had never been seen.
This is the world's largest act.
We bounced a plane, a boat, and a car, and it was wild. So today, How Ridiculous have 50 million followers.
We're in the billions of views.
Tens of billions.
That's pretty good.
I don't know all the things that we're going to get to do in the next year or 5 years, but if we can do this as a job, anything's possible.
Do you know what's really fun? Making a website on with.
The world wasn't built for guys like us. You think there's good and bad, right and wrong. There's just survival. The Penguin, streaming exclusively on Max.
Peace out, PMS. With Midol Supplements, Peace Out PMS. Shop now.
said 12:30, and we're a little after that because of the work on the sound thing, but that's gonna take way too long, so we're gonna have to have them do that after court today. Alright. Okay, let's get the jury in. Who briefly? Yes.
Thank you, Your Honor. Mr. Sledge, did you have a good lunch?
Yes,
All right, good deal. And is your head feeling a little bit better?
a lot better.
All right, good deal. Mr. Sledge, I want to just, and Judge, if I broach an area that the court has told me to move from, I'll quickly move from it. Mr. Sledge, are you able to tell me what you remember about April 28th, 2015? What happened on that day? Everything you can remember today.
Do you want him to tell you about the entire day? You don't, do you?
I don't. And so the judge is helping me out a little bit. So, starting from the point where you learned about Mr. Garlington getting jumped at the club, will you tell the jury, not the judge, the jury, everything you remember about it? Is that all right?
Yeah, I guess.
Okay, thank you.
From my understanding, like he got jumped on in the club, then I left the club, he called me back. We went and picked up Garland. I want to say Zachary, and then we went, I don't know the name of the apartments.
Okay.
And then I want to say we traveled back down, traveled back around. Is that?
I didn't hear you.
I said once we went to the apartments and then we went back to the house. I think that's what I said.
Take your time, and you do not have to. I'm not trying to get you to match up anything. Okay?
I asked her a lot. It's been long 4 days, so.
It's okay. Take your time.
If you have anything, you can refresh my memory. But right now, I don't recall.
All right.
Try my best.
And that's all I'll ask, okay?
Yes.
So I'm not gonna try and trip you up. I just wanted whatever you remember today in terms of it.
All right, go ahead and ask the next question.
Okay. All right. Do you remember whether you went to the house first or to the apartment first?
I don't remember. I can't exactly tell you, but I don't recall exactly how it went.
Okay. And the house that we're talking about, is that the one off near MLK, off Adele?
I want to say that's the only house I remember going to. I don't remember.
And where were the apartments that you remember going to?
I don't remember exactly what it was. I just know they was in a gated area. I don't think they had a gate when you gotta go through the gate. That's all I remember.
Do you remember whose they were? Whose apartments they were? Like, why were y'all going there?
I think I was supposed to been dropping Zachary off.
Okay. Did his girlfriend live there?
I don't think she stayed there, but she was there.
All right. Now, was there any shootings that went on there? Did you see somebody else shooting or anything happening there?
Yes, I think that's what it was. They was shooting when we pulled up.
Okay. Now, I know you don't get scared easily, but did you consider that sort of a startling sight to see somebody shooting at the apartment?
For me, it was normal, so I can't speak for no one else, but from my stuff, it was normal.
All right. And were they shooting at apartments that you were sending or taking Mr. Zachary to?
I don't know if it was the exact apartment, but it was right there in that area.
All right. Now, in terms of shooting, how could you tell the jury, because they weren't there? Do you see guns pointing out a window or just like fire flashes? What is it that let you
I
know?
just seen the fire flash in front of me.
Okay. And were you right up on the car, like, or were you like coming in the gate and you saw fire flashes from like across?
I pulled directly in front of the car and then I backed back.
Okay. When you pulled directly in front of it, had the shooting begun already?
No, they was doing it.
Okay. Did you realize they were doing it when you pulled directly in front of it?
No, it's like when we got there, then it started happening.
Okay. Okay, so for people who aren't you, that might have been considered a little scary. So what did you do when you heard the shooting behind you going on?
I backed out.
Okay. Did you back out and like quickly leave?
No, I got back to safety.
Okay. And where were Mr. Garlington and Mr. Zachary when you did that? Did they run inside, stay with you?
No, they got out the car.
And did you see what happened?
No, I was around the building, so I didn't really get out the car to see what was going on, but I backed up behind the people.
Okay. Did you have to pull around the car to get in front of it? Or did you?
No, it's a straight shot. It's just a straight shot through the apartment.
Okay, so is it fair? Did the car pull up behind you then?
What you mean?
Did I understand you to say that you ended up in front of the car that was shooting?
That means they was probably backed in, facing like coming out, and I'm coming in.
I gotcha. Okay. Did you notice what kind of car it was?
No.
Right. And did you have a belief as to who it was that was in that car?
I didn't know who it was.
Okay. Did you later form a belief as to who it was that was in that car?
No, I don't recall.
All right. Did you all do anything based on who y'all believe might have been in the car?
I already answered that question. I answered that question 2 days ago when I told you about it.
Okay. Forgive me, I had a long weekend. Could you tell me what you all did based on what you all believed or who you all believe was in that car? There's nothing more that'll happen as a result of it, I promise.
I don't know who was in the car. At the time, I didn't know who was in the car. I still don't know if that was true, what was told me, so.
All right. And that was told to you by Mr. Zachary or somebody else?
Well, it was told by other people too, so.
Okay. Other people that were there with you?
In the street, in the streets. Like, when things happen, it be talked about in the streets.
Okay. Did you all react immediately, or did it take a few days or something different?
I don't know. I couldn't really tell you because I told you I was behind a building, so I couldn't actually see what was going on.
All right. Okay. At any point, did you think that Ifgang was involved in that?
I don't know because I told you from the night that he got jumped on, I didn't even see who jumped on him.
Right.
So I don't know. I don't recall. I can't say that.
Okay, that's fair. I'm not asking you if they were. I'm just. Judge, may I be allowed to ask the question?
Yeah.
Thank you. I'm just asking you at any point if you believe they were, not whether you know, not whether they were, just at any point. Did you
No,
believe?
I never believe. I never believe.
All right. Now, we talked last week about Antrevia Smith, and you talked a little bit about that on cross-examination, your relationship with Miss Smith. The Kelvin Watts who started dating Miss Smith after you did, was that the same Kelvin Watts that had a beef with Kenneth Copeland?
I don't really know if him and Kenny Copeland had a beef or not.
Okay. So did you ever learn, or did you ever discuss any kind of beef that Kenneth Copeland had with Kelvin Watts?
I don't recall that we ever discussed this. I don't recall.
Okay. But is it fair to say that, let me ask you a better question so I'm not leaving. Is the Kelvin Watts that started dating Miss Smith after you did, was he also called Shell Kale?
Yes.
All right, thank you. And do you know if Shell Kale, did you consider him having any family relationship to Donovan Thomas Jr.?
I never knew they was, how long I've been knowing Donovan Thomas, I never knew they had any relationship.
All right. How long did you say you knew Shell Kale? If you said it already, forgive me.
I don't know. He wasn't outside when I was outside. He probably came outside. I started hearing about his name 2015. Before then, I never knew him.
Okay. When you say came outside, help me and the jury know what you mean.
Whenever he started hanging outside, I ain't know him before then.
So based on that answer, did he start hanging outside around 2015?
I don't know, Ms. Love. I'm saying that's when I started hearing his name in the street. Other than that, I don't know.
All right. When you heard his name in the street, did you hear his name associated with Ifgang, sir?
No, not when I first started hearing his name.
At any point later on, did you hear his name associated with Ifgang?
Yeah, maybe, yeah.
All right. Now, do you remember whether that was after 2015, like 2016, 17, or during about 2015?
I don't really recall because it was late. It probably late in 2015, but I don't know.
Sir. All right. Now, you were shown some dates in a book by Mr. Williams' attorney. I'm going to approach with the court's permission and with your permission. Is that all right? All right. So, did you testify, or a better question is, did you participate in every performance in 2015 that the Travis Scott Rodeo Tour included?
No.
All right. And do you remember when Mr. Steele was up here reading?
They call me prospects. The challengers of the world have taught me many things. These pioneers drive our generation forward by never giving up. Keep going forward. Prospects.
Craft together something special.
You can point them out and then read them out after you do. The dates that you did go to.
All the dates. I know exactly what day that I left that tour.
Okay,
I don't know the exact date, but I know what state I was in.
fair enough. So did the tour did not start until after January 10th, 2015. Is that right or wrong?
That might be right.
Okay. Do you know of any tour date on this tour that you were talking about with Travis Scott that started before February 28th, 2015?
I don't know the exact dates, at least I'm looking at the book.
Here. Do you know of anything before February 28th, 2015? Here, you can turn however you want to look at it.
No, the first date say February 28, 2015.
Okay.
Yes.
And to your memory, is that the very first date of this Travis Scott tour?
Yes, from my memory.
All right. Now, this tour, when we say Travis Scott tour, who was the headliner? Was Mr. Williams the main attraction, or was Mr. Scott or somebody else?
Mr. Scott was.
Okay. Now, was he a major performer? And you got to forgive me because I don't know Travis Scott, okay?
Come on.
I'm not lying. I don't. Was he a major performer? I'm older than you believe, and you're going to have to forgive me.
Come on.
I'm dead serious.
Yeah, don't be mad at me if I'm laughing at you.
I'm not mad at you.
You just listen what I'm telling you.
Okay.
I know a lot of people know he's a big major artist.
Okay. All right. And is he a rapper, a singer, a musician, or something
I
else?
don't really. I think he do like, is it like rock or something like that? I don't really know.
Okay. All right. So he's a big performer. And did you go on that very first tour date on Saturday, February 28, 2015, that's listed on the book?
I just told you, yes.
Thank you. Were you head of security for Defendant Williams on that day?
I want to say, I don't recall if I was or not, was I head of security, but I did a lot of different things on it too.
All right. Okay. Thank you for that. Now was that in Santa Ana, California?
Yes, that's what the book would say.
All right. And is that your independent recollection, apart from what the book says?
I don't really remember. I could just go by the booklet and know the actual day and what state it was in.
Okay. And so does looking at the booklet make you remember, or are you just relying on the booklet to be right?
I knew the booklet was right. I had one myself.
Okay.
In that time.
All right. Do you remember who else within YSL went on this tour?
It was a lot of us. I don't recall everybody who was there.
I'm sorry.
It was multiple, so I don't recall everybody who was there.
Was that the first time you had gone to Santa Ana, California?
Maybe not, but with a major upcoming artist it was.
Now, were you all with YSL? Were you all like traveling with Mr. Scott, or were you all traveling separately? How did that work?
We traveled separate.
Okay.
Mr. Scott, not my friend.
Understood. When you got to the venue, wherever that was, did you all stay in the same location as Mr. Scott or separately?
I can't remember. They normally have different dress rooms, so I don't recall.
All right. And did you stay overnight, or did you all just perform and leave?
You perform and leave. At least he had to be there more than one day, so I don't know. If his booklet says 2 days, sometimes we stay 2-3 days in the same state. So you might go to Dallas, you might go to Houston, stuff like that. So.
And was Mr. Stillwell with y'all on this tour, February 28th, 2015?
I think so.
What about Mr. Kendrick?
I think so.
All right. Anybody else in this courtroom that would have been with y'all then?
Not that I know of.
All right. Now, March 1st, that's listed here. Did you go on that one too?
March 1st?
Mm-hmm.
I was there every day except the day that I told you that the state I remember that I went home.
Okay. So, are you able to say, just from memory, where or which ones you remember performances occurring at? I'll give you the book.
I can't remember all that.
All
I
right.
don't recall all that.
On the days that are listed as travel days, are you able to tell the jury if you all actually traveled on those days, or were there some days that you all traveled on different days?
Probably actually that day, because you had to be in another state before he performed. It was a time limit, so like we had to stay on the time limit.
Okay. Are you able to tell this jury with 100% certainty whether or not Mr. Williams performed at every show reflected on this tour schedule?
I can't say that because I got sent home on a certain date, so I didn't finish the whole tour, so I can't say that.
Okay.
I didn't see him perform, but until I got sent home, I seen him perform.
Without looking at the book, and I'm going to show you the book in a minute, but without looking at the book, are you able to say the date you went home?
I can't tell you the date. I remember what state it was.
Okay. Looking at the book, would that help you remember when you went home? And does that schedule just consist of that one page, or is there two pages?
It's one page. I remember right here.
Are you,
I got my finger pointed back.
okay. Can you read out the
date?
date?
It was Thursday, March 26, 2015.
Thank you. Are you able to tell the jury with 100% certainty whether on every tour day prior to Thursday, March 26, 2015, Defendant Williams performed at every performance listed on this sheet of paper?
Not after that date, yeah, but that date, yes. That's the last show I was at.
What I'm asking is, before you got sent home, before you went home, right?
Every show day he performed.
Every show day?
Yeah.
Okay. Do you recall who all was at the shows that he performed at every day before March 26, 2015?
No, I don't recall that.
After you got sent home, did you make any effort to follow what was going on as he toured?
No.
So when you got home, did you just kind of blank out and not listen to her?
I enjoyed myself with my family.
Okay. Did you speak with or talk to or communicate with Defendant Williams or any other member of YSL who might have been touring with?
No, because I was trying to get family time in, so I didn't call and see what Mr. Williams had going on. I was more focused on my kids.
When you got sent home, would you tell the jury how it was that you were sent home, like by bus, train, plane, car?
I don't even think he sent me home. I requested that I was ready to go home, but I went by plane.
Oh, okay. Did you, did that request have anything to do with your family? What happened?
No, I was just ready to get home and see my kids at the time.
Fair enough. Did anybody else leave at the same time you did on, was it March 26, 2015?
I don't recall who all left at certain time because everybody didn't leave and go the same way they kept on the plane.
Okay. Was Defendant Stillwell still with Mr. Williams on this rodeo tour of Travis Scott's when you left? Do you remember?
I don't recall if Mr. Williams and Mr. Steele went home or he stayed on tour. I don't recall.
Do you have any memory about Mr. Kendrick and how long he stayed?
No, I believe Mr. Kendrick stayed the whole while. If I'm not mistaken, Mr. Kendrick was like a backup hype man or something at the time.
Was a backup hype man?
He was on stage with him performing.
Okay. Was Mr. Copeland with him? Do you know?
No, I don't remember Mr. Copeland.
What about Mr. Zachary?
I think Mr. Zachary had got sick. He went home way before.
Was Mr. Stevens with him?
I don't recall.
What about Mr. Garlington? Was he with them?
I don't recall.
So without me going down a list of people you don't recall, can you tell the jury if there's anybody else you recall being on this tour of Travis Scott's with you and other YSL people?
No, I don't recall.
DK, Walter Murphy, was he ever any point on this tour?
I don't recall.
Do you recall ever being on tour with Mr. Murphy?
I think I was at one point in time, but I don't recall when he left. I don't recall that.
Okay.
I won't say that he was never on this tour.
Yes, sir.
But I don't recall when he left off the tour.
Okay. Now, is this tour that you're just pointing to, is that the only tour that you've accompanied Defendant Williams on as either head of security or something else, or is there any other tour that you can tell the jury that you worked or were a part of?
From my understanding, what I know, I only know about 2 tours. I don't forgot what the second tour name was, but I was there.
All right. Was that after or before the one?
It was after.
Do you remember how long after?
It probably 2019, I want to say.
Okay. And was it in the States or was it like in other countries or something different?
We went to Atlanta, but it was different states. And I think like on the tour, he did go to another country at one time.
Say it for me one more time, sir.
I think he did go out the country on one of the dates. I just don't remember what date.
All right. Do you remember whether he was the headline by 2019?
Yes, he was headline.
Okay. And did he have other artists performing with him?
Yes, his artists.
All right. Besides people from YSL, like with this, he was performing with Travis Scott. Did he have some other people besides YSL performing with him in 2019?
I don't remember the guy's name. It's Kelly, something like that. I think it's something like that. I don't want to use the term of what his race is, but his name Kelly or something like that.
Was he my race?
No.
Okay.
He was his race.
It was his race.
Yeah. Since you want me to see.
You're all right. That's all right.
Yeah.
All right. Was it Machine Gun Kelly?
That's who it is, Machine Gun.
Okay. All right.
I'm not familiar with all the rappers, but.
Okay. But Mr. Williams was the top line and Machine Gun Kelly
was, yes.
with him. Okay.
Yes.
All right. Now, am I reading correctly that this rodeo tour lasted February 28, 2015 to April 3rd, 2015?
That's what it's saying. The booklet, that's what it is.
And you can look other pages if you need to.
I don't think it's no. Okay. Yeah, that's the ending date.
Okay, so is it your memory that after April 3rd, 2015, where it says travel home, there was no more rodeo tour?
No, there was no more rodeo tour.
Okay. When you worked on the tour in 2019, do you have a rough estimation of how many places, how many cities y'all visited?
No, it was a lot.
Okay. And do you have any idea of who all within YSL would have accompanied you and Defendant Williams on that tour with Machine Gun Kelly?
I don't recall everybody who was with us.
That's fair enough, Mr. Sledge. Do you recall anybody though?
Person I remember that, I know Mr. Kendrick was there.
Okay. What about Mr. Stillwell, 2019?
I don't even remember what Mr. Stillwell. No, I don't think. Well, let me back up.
Yes or no? Don't
tell
me.
Can I bag up? I don't even think Mr. Kendrick was there. I'm sorry for that.
Okay.
I don't think Mr. Kendrick was there.
Okay. Was Mr. Murphy there to your knowledge?
No. I don't recall.
All right. What about Mr. Zachary?
I don't recall.
Okay. And did you and Mr. Williams, y'all stay at the same hotel and things like that on that tour?
Yes, I was basically everywhere it went, probably like my room was like next to his, probably up on the floor.
Okay. Now, when you talked about earlier knowing Mr. Williams' music, but you can't recall always songs, are you familiar about any YSL members that he talked about in his songs?
I don't recall. You got anything to refresh my memory? Can.
All right. Do you have any memory of any songs that Mr. Williams referencing a woman getting robbed by a tick? I do so. I blank her and she get robbed by a tick.
I don't recall. That was in the early time. I don't recall that song.
Okay. When you say in the early time,
I'm saying like in the beginning of his career, I don't recall that song.
For you, can you tell the jury what you consider the beginning of the career, the earlier part that you wouldn't remember, just so they have a frame of reference?
Probably, I guess around his early career, I can't give you exactly the year.
Okay. 2014.
Even if you tell me, you don't got it in front of me, I can't tell you.
All right. Okay. What about Lil Woody popping at your night? That sound familiar?
Yeah, I think that was on the song.
Do you remember what song that was on?
I want to say Halftime, if I'm not mistaken.
Any idea when Halftime dropped?
No, I don't remember exactly what year Halftime dropped.
Okay. Do you remember around like 2014, 2015?
Don't remember that.
Okay. Were you working as head of security during that time?
I don't recall that because I don't know what year. I can't answer that for you because I don't know what year it came out.
Okay. In March 2015, you said you went home around March. What was March?
Well, that was Phoenix, Arizona.
Phoenix, Arizona.
After that show, I went home.
Okay. All right.
Or it would have been the next day that I went home.
Okay. All right.
So I didn't travel to the next state with it.
All right. All right. So March 26, 2015 is Phoenix, Arizona. You would have gone home like March 27th, that Friday.
Yeah, that morning.
That morning? Okay. All right. Did you ever hear, sir, you want to see it again?
No.
All right. Did you ever hear, while you were there, before you went home on March 27th, did you ever hear Defendant Williams refer to any other artists in his music while he was on stage? Other than Travis Scott?
I don't recall because I don't recall all the songs he performed.
Okay. Did you ever hear him diss anybody on stage?
I don't recall.
And I'm going to have to say the word, but I hate to do it, but I'm going to ask. Did you ever hear him call anybody a bitch on stage?
I don't know. He probably said bitch in a lot of songs. I ain't going to say that. He called no one no bitch. I never heard him call nobody a bitch on stage.
Okay. And did you ever hear him refer to anybody substituting one part of their name for the word bitch?
No.
Okay. When we were talking about that video with you, Mr. Zachary, back last week, the video, I'm sorry, I'm switching gears. I'm switching gears.
Yeah.
But I ain't
that's how
you,
that's how you confuse me. You go to one subject and then you jumping all the way left field.
All right, I'm gonna try and orient you. Last week, when you and I were talking, do you remember me putting up a video of you and Mr. Zachary, and one or both of you had a gun, and you were saying something like, "We're not going back and forth," and you were talking about Kale in the video.
Right.
All right. When you were Do you remember when it was that you filmed that video? Not posted it, but filmed it.
I don't recall when we filmed it.
Okay. And when you were filming that video, do you remember saying that at any time that it wasn't about a girl?
I don't think we never even mentioned a girl name in the videos.
Okay. So is it fair to say, or is your testimony that the stuff you said to Kale wasn't about no girl?
I don't recall. I can't say. So I don't recall. You said what I said. I don't recall because I ain't say nothing about no girl in the video.
That's fair. All right, but do you remember the video?
I remember we made the video, but I don't remember what I said in the video.
Ms. Dyer, are you able to pull up that video? What number was that? 441. All right. We're going to play 441 for you one more time.
You little strip-ass nigga. We ain't really going back to no nigga. You little bitch-ass nigga. I know what we hate. Yeah, fuck you, nigga, champ. Who else else? Nigga, what, nigga? Nigga, what? They said I ain't really going back.
You're chuckling.
Now, funny now.
It's funny now?
Yeah, that video.
Now, who other than Kale were you talking to when you said, and whoever else?
I just said whoever else.
All right. Now, what were you meaning to tell Kale?
I wasn't them to tell him nothing.
Okay.
I said what I said in the video.
All right. Which was, we're not going back.
I ain't going back and forth with him.
All right.
I ain't say them, I said him.
Was he trying to go back and forth with you about something?
If you want to be honest, they were saying that he was looking for me about treatment. So that's the whole thing. So when he didn't respond to me when I DM'd him, I made sure he was gonna be able to see what I was saying.
Can Stonyfield organic yogurt with high quality ingredients and no harmful pesticides save the world? Maybe not, but it could save you from saying we have food at home. Again. Stonyfield organic, good on purpose.
What was Mrs. Zachary doing up in there with y'all?
I don't know, they were just being silly in the video too. It was all silly. It wasn't in that serious. Cause when I seen Kel, he ain't do nothing to me. And when I ain't do nothing to him. So it wasn't that serious.
So for you putting guns on the internet, ain't that serious? Is that fair?
No one was shot. So I don't think it was that serious. So the video. They'll also walk around with guns all day. It ain't that serious.
All right. When you oriented you back to the rodeo tour, not trying to switch up and change you and confuse you.
That when you first screamed that. You went from here to there to there.
I'm trying to get past it and go
and
fast.
I'm trying to stay focused with you, but you started throwing me off.
All right.
Come on.
When we're talking about the rodeo tour, you said you had to go home, but you were working. Did you have any kind of contractual obligations you had to fulfill before you went home?
He'll let me go home anytime I wanted to, no matter what the contract was. He'll let me go home. If I tell him I want to go home and see my son, he'll be like, he'll let me go home.
All right. And did you have someone to replace you when you went home?
Yes, I was head of security, so that means I only choose the security. That don't mean I did security. Head of security just means like I could come say, we're gonna get me love, we're gonna get him, we're gonna get her, we're gonna get Mr. Right. And if one of you don't do right, I just say, we'll give him a plane ticket.
Did you have responsibility for sending folks home to act it up on the tour?
No, I don't have responsibility to it.
Okay. Now, on cross-examination, going back to
Israel.
Thank you. This is defendant Williams number 255, right?
Yes.
All right. You told Mr. Steele that you had seen that, you recognized that before,
Yes.
right? Where had you seen that?
If I am mistaken, man, when it was posted and added, I want to say me and Mr. Williams was together.
When it was posted and added, y'all were together?
When the guy added him, me and him was together. That's why I remember this post. And we were both like, I think he was gonna try to use it in a song or something, but he did. I don't know.
Okay. Are you familiar with D-Mac, Got Me Too Banging?
I don't know him personally, no. I don't know him.
Now, where was it that you saw it?
I want to say that was Twitter or something at the time, if I am mistaken.
Now, are you tagged on this tweet too?
No, what are you getting at?
The jury doesn't know, so I'm just asking.
You showed that they presented it, and they see I'm not tagged on them.
So when you say that you and Mr. Williams were together, were you looking at his Twitter account?
Yeah, we were sitting there looking at the phone together.
At Mr. Williams' phone?
Yes.
All right. I'm going to pull up what I will mark for you as State's Exhibit number 4. Judge, I'm going to, for the purposes of this question, mark the clip that I'm going to show as State's Exhibit 449. And it is from 1:03:30 to 1:08:17 of Mr. Sledge's testimony on September 5th, 2024, when I asked about the video of defendant Williams speaking into the camera, talking about they lied to them all. Last week.
Oh.
Just last week.
I've been saying.
Yeah. Just take a look at it, if you will.
I will.
Okay, thank you.
I'm not trying to give you no hard time.
Thank you for trying not to give me a hard time.
Take a look at it.
My apologies. Yes. Mr. Steele, do you mind coming over to Miss Knight, so that she can show you what we're about to show?
Anybody else? Any of the other?
Anybody, yes. And Judge, so that our record is very clear, it will be 449 Yankee.
Okay. Thank you.
And thank you for not giving me a hard time.
I don't want to. I just want to get up, get out of here.
All right.
I don't want to give you no hard time.
Is it done? Judge, just so that the court's aware, we're making it available, but we're planning to do the transcript so that the volume isn't overheard by anybody else in the courtroom. And with the court's permission, I'm just gonna sit while they're looking.
No, I'm good.
Okay. Mr. Steele, is that right? Did you want to
Oh,
approach
I
about
mean-
a particular section? I mean, did you, is there, do you want to? Oh, okay, all right. Do y'all need a break at all? Okay.
Jesus.
Pledge, I'm going to put in front of you a portion of your testimony that we have and will mark as 449 Yankee, just for the purposes of the record. And I want you to listen to it. It will be approximately 2 minutes. And after you hear it, would you just tell me if you remember that? I don't want to ask you just straight out, do you remember something, okay? I don't mind, Judge. I'll tell him if you like. Give me a second.
Okay.
Judge, that will be from time 103, 1:03:30 to 1:08:17. Yes, a little more than 2 minutes. I mean, yeah. I'm sorry. Me and my bad math.
You're trying to listen to me, see. Can't you understand what I'm saying? Can't understand. Just put anything in my ear. All right, that's it. I don't want to put nothing in my ear to nobody else. Yeah, do something different. No. That- But I don't want to use it. You gotta get something else. Yeah. That's a perfect. You ain't fin- I don't want to wake up, my ears broke out. You ain't gonna pay it. You ain't gonna pay that doctor bill. Okay. Right. Me neither. So let's just do it the right way. Yeah.
You can pull it.
Oh, okay. Sure. Oh, okay. I just want to make sure I'm here.
Okay.
It back on. I don't remember. Okay.
Visit Global Industrial today and find over 35,000 exclusive brands products on our website. Our Global Industrial exclusive brands products are made only if they exceed expectations and can deliver value. Made to exceed. Global Industrial. We can supply that.
Feeling the love, not the congestion. Live Claritin Clear.
You can get it. It ain't bad, but you can get it. I know what you're talking about. You can stop if you want. You stop. Yes.
Mr. Sledge, having heard what you said when I asked you about states 449 Yankee, do you recall my showing you the video of Defendant Williams looking into the camera, talking about they lied to their mama?
Yes.
And do you recall me asking you whether that was your voice in the video?
I told you it sounded like my voice.
And do you recall me pressing you, asking you, was that you?
When you just showed me the video, I see now, but that's why when I told you it sounded like me, I thought you just took it as that was me, because I told you it sounded like me, and the only way it could sound like me, I had to be there in the room.
Do you recall telling me that you did not remember being in the room?
I see on the video I did, but like I tell you, you were pressuring me so much that day too. My mind just was everywhere.
And when I asked you if that was you specifically who said snitching bitches,
I said, yes, that was me. That was my voice. Sound like my voice. That's what I said.
did you ever acknowledge though that was you in the video?
I said it sounded like my voice. So yes, I acknowledge that was me if I said it would sound like my voice. I ain't said it sounded like Miss Love, and I said it sounded like me, that record, that to me, that's saying it's me.
All right. Do you recall me asking you where you were?
I said, and I told you I didn't remember what house it was, but I did. I said that sounded like my voice.
Do you recall me asking you who all was in the room?
I don't recall you asking me that. I ain't hear that on that either.
Do you recall me asking you the names of anybody else that was there?
Not I recall you didn't ask me about nobody. You was on the Pacific asking me about my voice. That's what I remember.
And do you recall at some point telling me, I'm not saying that it's me, I'm just saying it sounds like me, so I can't tell you?
Yeah, I told you it sounded like my voice. That's all I remember telling you. It sounded like my voice. So I know if it sounded like my voice, I just thought I'd say, yeah, that's him. He said it sounded like his voice.
Do you remember Doug's attorney showing you the same video a day later?
Yes.
Do you remember him asking you, was that you in the video?
Yes.
Do you remember telling him, yes, that is you in the video?
Yes, because I had the day to think about it, and then I was like, yeah. When I was still planning in my mind when you showed it to me, and then I thought about it, I was like, yeah, that is me in the video saying it's my voice.
Is that the video that you were thinking of when you were talking to me back in June with your attorney, Lieutenant Lancico, and myself out in Fayette?
I don't even remember you asking me about that video, Ms. Love.
Do you remember me telling you on direct or asking you on direct about a video where I asked you if you had seen or did you know the video where they say you lie to your mama, you lie to your kids, and you said that wasn't me?
No, I remember telling you I didn't see me in the video. I seen Mr. William in the video, but I don't recall the statement you make.
Thank you. And do you recall me asking you then, where had you seen that video before we met in Fayette?
I don't recall, but I just heard it. Something about you asked me that, and I told you I seen it before time, and I seen it recently.
Now, between the time I showed it to you and the time that Mr. Steele showed it to you, did you go look at it and listen to it again?
No.
And so what happened that made your memory precise about not just the fact that it was you, but where exactly it was shot? I'll clear it up. Bad question. Do you remember telling Mr. Steele where that video was taken?
I don't recall Mr. Steele even asking me where it was taken. I don't even recall him asking me that.
Your Honor, can I object at this point, 403?
I mean, we've all heard the testimony, so whether he remembers it or not at this point's not really the issue. Can you just ask the questions you intend to
Sure,
be
Your
asking?
Thank you. Mr. Sledge, why did you remember who all was in the room when the video was shot, when Mr. Steele asked you the question?
I just told you, when you asked me, I didn't remember, but when I left that day, I thought about the video, and then I realized everybody's voice who was in the video.
Okay. And what about the time or the date that the video was shot? What did you remember that too after you left?
He showed me the date of the video he had, and then I remember it was a repost, different date. I don't remember the date of the repost, but I knew what he cross-examined me on. I knew the answer to that question.
And do you remember me asking you about what what you understood Defendant Williams to be talking about when he said they lied to their mama, they lied to their sister, and all that stuff? Do you remember me asking about that?
No, I don't remember you asking me.
At any point, having heard the video again today, did you hear anybody reference lying in the courtroom on that video?
Yes.
You heard somebody say something about lying in the courtroom?
Oh, no. You said lying in the courtroom?
Uh-huh.
I don't even know if I just heard that, Ms. Love, to be honest with you, but I think I did. I'm not mistaken. If you got anything, just show it to me.
Your Honor, state request permission to play against states 447 Yankee.
That's
The video itself.
Okay. All right.
And so even hearing it just now, you didn't remember, right?
No, if you show me again, like, that part.
Okay, don't worry about the earphones. We're gonna put it up on the big screen.
So nigga, a lot of they mama, a lot of they kids, a lot of they brothers and sisters, they ain't get ready in the courtroom to tell the God and his truth. Don't get it. Y'all nigga need to get fucking killed, bro.
You snitching
bitches? For me and what I said.
I don't hear it say lying in the courtroom. Though.
All right. So when you were asked on cross-examination by Mr. Steele if that video talked about lying in the courtroom, and you said, yeah, was that a mistake?
Yeah, that was a mistake. Cause I didn't say lying. It didn't say lying in the courtroom. The voice didn't say lying in the courtroom.
Okay. What did you understand it to be saying?
What he said or what in the video it said.
The video.
It's something loud on God.
And when Thug is talking, what is he talking about doing in the courtroom? Telling the God's honest truth?
Yes.
All right. And after Mr. Williams says, and you get in the courtroom and tell the God's honest truth, you need to get killed, bro. That's from me as YSL. Since you realize now that that is your voice, Would you tell the jury why you say snitch and bitch?
Because snitch is a liar to me.
Did you just not say that he said you get in the courtroom and tell the God's honest truth?
Well, I'm in the courtroom telling the God honest truth. So whatever he said, what he said.
So when he about telling the God's honest truth in the courtroom, why follow that up with snitch and bitch?
I just said something. There wasn't no reason to follow it up.
Do you consider a person who does get in the courtroom and tell God's honest truth on their friends snitching bitches?
No.
You were also asked on cross-examination by Mr. Steele about a meeting that you had with Lieutenant Lansco, your lawyer, and me out in Fayette County.
Yeah.
Call that?
Yes.
Did you let Mr. Steele know before we met that we were actually going to have the meeting?
Did I let Mr. Steele know?
Yeah.
No, I hadn't talked to Mr. Steele before.
All right. Did you let anyone in his office know that we were going to have that meeting?
No.
And afterwards, did you let him know that we had just had it?
Could you be more direct? What you trying to say?
Only what I'm asking.
You said, did I do what?
Did you let Mr. Steele know that we had just had that meeting?
When? After we had the meeting?
Yes, sir.
Yes, yes.
Okay. Did you ever let me know that you had that Zoom call with Mr. Steele?
No, I ain't. Because my lawyer put the Zoom call together. I didn't put it together.
Okay.
Mr. Steele didn't call my phone himself and say, Mr. Sliggs, what's going on? No.
Okay.
My attorney was on the Zoom call.
Okay. And on the Zoom call, or rather last week, Mr. Steele asked you very pointedly, if you recall, do you remember Mr. Steele asking you, did Miss Love, or did you tell Miss Love that Defendant Williams encouraged you to take Kenneth Copeland to the police station?
I said that to you and Mr. Steele.
Do you recall Mr. Steele
asking me that?
you
Yes, yes.
Do you recall Mr. Steele asking you, did Miss Love tell you, do not tell the jury that Defendant Williams encouraged you to take Kenneth Copeland to the police station?
I wouldn't say it was saying like that.
Hold on a minute. Do you recall him asking you that?
Yes, yes.
And do you recall telling him, yes, Miss Love told me do not tell the jury that Defendant Williams encouraged me to take Kenneth Copeland to the police station?
You didn't say it at the meeting June 9th. You didn't say it that way. But when I brought it to your attention that Mr. Williams told me to take me and Kenneth Copeland to the police station, your exact words to me, I don't want you to say that, and I will not be asking you that question.
So, at what point did I tell you not to tell the jury that Defendant Williams encouraged you to take Kenneth Copeland to the police station?
You didn't use the word jury, but that's the way I took it, because from my understanding of this process, that I would be speaking to the jury to try to prove the facts to the jury, and I just thought I should come in and tell my truth.
When your lawyer and you, Lieutenant Lancico, and I sat outside that coffee shop, were you in any kind of handcuffs?
No.
Did you come on your own?
I came with my lawyer.
Did you leave on your own with your lawyer?
Yes.
And did anybody try to read you any kind of rights or anything like that?
No, you know that. I would have been in
But the
jail.
jury doesn't know that, okay?
Right.
So, did you feel free to say whatever you wanted to say?
I just told you, I said what I said, free, yeah.
All right.
I'll freely say what I want to say.
Okay. So during that conversation, were you encouraged to come into the courtroom and simply tell the truth?
Yes.
Were you encouraged to simply tell the truth by me?
You said it out your mouth that you wanted me to come in and tell the truth, but you said it out your
Were
mouth.
you encouraged to tell the truth in front of Lieutenant Lancico and me by your attorney?
Yes.
As a matter of fact, did your attorney tell you to act as if any question the state asks you, they already know the answer? So don't try to finagle anything. Tell them the truth.
I don't recall him saying that in the meeting.
I hate to use this, I'm not being blasphemous, but did your attorney tell you to pretend like the state is God and they know everything?
No, he didn't say that.
Okay.
I know that. You heard me.
Do you remember me asking you about the video? Do you remember me asking you about the video and you're denying being in a video where you say you lie to your kids?
I never denied the video. I said you don't see me in the video. They're my exact words.
Right.
That ain't denying the video.
Okay. And do you remember after that I said, I've seen a video with you in it?
You said you seen the video with me, and I said you didn't see no video with me in it.
And do you remember me saying, yes, I have?
But
and you kind of smiled.
At the time, you were referring to the video that Mr. William posted, not the video that I posted. Because if you would have seen the video that you posted, Mr. Sledge, I would have said, yeah, that's me in that video.
Mr. Sledge, did I make reference to whose video it was? Or did I just ask you about
I
the
think
video?
you made, to me, I thought you, when you brought up the video with Jeffrey in it at first, then you brought up another. You brought the video up of Jeffrey. Because I told you that wasn't me. And then I said, you didn't see me in no video.
Okay, no problem. Now, on direct examination, do you remember as you sit here today, me asking you whether Mr. Williams encouraged you to take Kenneth Copeland to the police station?
In this courtroom?
In this courtroom.
Yeah, you asked me the question. I figured you asked me the question because my lawyer called me and asked me, what did you, Ms. Lord, say to you in that meeting? So then when you told me at the meeting, you wasn't going to ask me the question, but then you get in the courtroom and ask me the question.
So.
That's what happened.
Okay. So was it that I said I'm not going to ask you that, or did I tell you not to tell the jury that?
You said how I took it.
How you took it. I just need to know my words. John,
it's non-responsive. Ask your next question.
My words only. Did I ever tell you not to tell the jury that Defendant Williams encouraged you to take Kenneth Copeland to the police station? Did I ever tell you that?
You just said you didn't want me to say that.
Okay. Now, is it your testimony that I said, I don't want you to say that, or I'm not going to ask you that?
You both of them.
Overruled. We don't really have a clear answer.
And it's your testimony that your lawyer and Lieutenant Lancico were still right there when I said these words that you heard?
Yes, but I wouldn't have said it.
All right. And based on what you just testified to the jury, you gleaned from that I didn't want you to tell the jury.
I never used the word tell the jury. I just said exactly what you said to me. I say, Ms. Love told me that she didn't want me to say that, and she wasn't going to ask me that question.
Okay, so then your memory is not, you don't remember telling Mr. Steele. You do not remember asking Mr. Steele saying, did Ms. Love tell you do not tell the jury?
If he said jury, I forgot I made a mistake, and I should have corrected Mr. Steele if he said jury. But I'm telling you what you said to me in the meeting. I ain't saying you said don't tell it to the jury. But that's the way I took it too, cause that's who I'm supposed to be talking to, right? Telling the truth to, right?
Right.
Okay, so in my way, not the lawful way, that's the way I took it. Cause if somebody tell me, oh, I don't want you to tell my girlfriend this, I'm gonna take it as, you know what I'm saying? You don't want me to tell the truth.
Okay. So, all right. So were you surprised when I asked you, did he encourage you to take Kenneth Copeland to the police station if you thought I didn't want you to tell the jury? I'm exploring what he said his understanding was.
Overruled.
So were you? When I asked you that question, were you surprised given that you thought I didn't want you to talk about it?
I don't know. I can't recall. I don't know.
Now, on cross-examination, did you tell Mr. Shart that you didn't feel like you could go to trial, or you didn't have the ability to go to trial? And
That's how I couldn't afford to go to trial.
Okay.
That's the question he asked me. He didn't say ability, he said afford.
All right. And that's the reason that you answered yes to all the questions that you answered yes to on State's Exhibit 444 Yankee and 1AS?
I don't recall.
Having had time to think about it now, do you remember and realize that your sentencing acknowledgments placed you in peril of probation revocation if you testified inconsistently with something you said was true during your plea agreement?
I don't think I testified nothing that wasn't true today, if I recall.
Do you remember testifying on last week when I asked you specifically about portions of what you agreed to, and for you to tell me if any part of it you're now testifying is false, to label it false, and if any part of it, if it's all true, to tell me it's true? Do you remember me having that conversation with you?
I remember the conversation, but you had put so much on, I don't even recall what went on.
Do you remember me putting in front of you, Stacey, 447Y? And
Yes. You'd like a new question? Oh, okay. All right. Whether he remembers it or not is not really the relevant matter.
Oh,
all right. Did you testify that
I never
number?
Not highlighted. All right.
Did you testify that number? I took it. I put it back. This is it. at 1AS. Here it is, okay. The second part. Did you testify that, looking at this, at State's Exhibit 1AS, did you testify that number 3 under defendant's factual acknowledgments is not entirely true?
No, I didn't say it was not entirely true. I think I remember I said the part of the support of YSL, and you put care as a rival game, and I told you I didn't even know he was their game at the time. And if I made a mistake anywhere else, I made a mistake.
All right, do you remember me putting, now I have to ask, do you remember, Your Honor? Do you remember me putting State's Exhibit 444Y in front of you?
I remember you putting all these papers in front of me, but I'm like.
Do you remember me asking you to go over each number, and if one of it is true or one of it?
Oh, no.
Do you remember me asking you that if all of the statement is true, to tell me and label it true, but that if any of it is not true, to call it false? Do you remember that?
I don't recall that, Ms. Lil. Like I told you, you've been confusing me for so many days. You've been confusing me since I've been on this stand. So I don't know, like now, you jump from one thing to another thing. My brain don't move as fast as probably yours. I might don't learn as quick as you do. So I don't remember all this stuff. You putting all these papers in front of me ain't gonna make it.
Okay. All right.
So whatever you trying to get to.
All right, we're just getting to the questions. So we'll take it slow.
I don't remember.
All right, 1AS, that is the document you signed, right?
Yeah.
On 1AS,
I don't want us to go over the whole direct examination.
I'm not.
This is supposed to be redirect.
I'm not, Your Honor. I'm specifically asking questions that are related to what the witness responded to on cross. So on cross-examination, the witness was asked whether he was allowed to craft this, whether they were his words, whether he understood them, whether he felt compelled to.
I recall.
And so what I'm asking now, and he was also asked on cross, whether he felt between a rock and a hard place.
I already answered that question.
So what is it that you
And
want to ask him?
I believe that he testified on cross that one part was feeling between the state and the other was Fulton County Jail or going back to jail. So I'm asking him about his sentencing acknowledgments and what he has stated or agreed to within the sentencing acknowledgments, and how that squares with his rock and hard place on December 28, 2022.
Okay, then ask him that, how those acknowledgements square with his rock and a hard place.
I don't think that's gonna get a quick answer, but I'll ask. Okay, so Mr. Sledge, how do your sentencing acknowledgements square with? Do you understand that you
Now you
said?
thinking this stuff funny.
No, sir, I don't. Mm-mm.
You do.
Do you
laughing,
understand?
Cause I know your question ain't funny.
It is not.
So what you laughing for?
Mr. Sledge, do you recall stating in your sentencing acknowledgements?
I don't recall.
Well, you have the paper in front of you. Would you please look at it to refresh your memory?
They still don't refresh my memory.
Your Honor, the state tender states Exhibit 1AS as evidence of a prior past recollection recorded. Yes, it was, and it was agreed to.
I object as well, Your Honor. This is not past recollection recorded,
It
and
is.
past recollection recorded does not come into evidence. I have to get you the code section.
You're right, it doesn't. You read it into the record.
That's exactly right.
We already read it into the record, though, and not we, but you. You already read it into the record once.
Your Honor, I'm asking, all right, fine. Mr. Sledge, do you understand that you agreed that if you fail or refuse to testify to any fact that you acknowledged in this plea agreement, that such failure or refusal nullified any promise by the DA to null pros count 30 of the indictment.
Objection asked and answered.
Sustained. And we've already established that he adopted all of those things.
So understanding that as of last week, you understood the sentencing acknowledgments, it did not place you in what you called between a rock and a hard place with Mr. Sharp, as far as coming in here and testifying to something different than what you put in the factual acknowledgments.
I came, from my understanding, I would be able to explain the things that you wouldn't change. That was from my understanding. So now I'm here testifying my truth and not what you put on paper and your answer. These is not my answers on this paperwork. Yeah, I did sign it, but if you would have came to me personally, like I think you should have did, and asked me this yourself, I would have told you no.
Did you testify that lay low were my words and not yours when I asked you on direct examination about defendant Williams giving YSL members money to lay low after the murder of Donovan Thomas?
When you asked me at that meeting, I told you he could have gave YSL money to lay low because I'm the only one who stayed in Atlanta. I told you he gave me money to get out of harm's way. I borrowed $300.
I'm talking about in court last week. Do you remember saying, I didn't say lay low, those were your words?
That is your word. I didn't say lay low. That was already on this paper. I never used the word lay low to you not one time. All this stuff that you trying to say, it was already on the paper. You changed certain things and then we agreed, and then I'm gonna be honest with you, I didn't even want to say that. I got another paper that's saying you changed number 8. It went from one thing to another thing. You don't want to red flag that.
No, I do.
Okay.
So, thank you.
Because you changed the personal knowledge and I ain't changed it.
Thank you for that.
I would have never said yes to that. When I got to the last paperwork, I thought we had an understanding of what the emails my lawyer sent you.
So do you now remember getting multiple versions of states 444Y that was changed at your request?
Not all of it.
Okay. Well, let's just show you. And you tell me which ones you remember.
So I ain't gonna let you remember none of stuff.
Okay.
I ain't gonna remember none.
So do you remember asking the state to change more than one thing on the factual acknowledgement?
A lot of things.
Do you remember the state making changes at your request?
I don't really know because I seen something different today that it wasn't what I thought it was the day I agreed.
Do you remember last week testifying that you hadn't seen any other document besides the one you signed?
I just seen them today.
Okay.
I didn't see it. My lawyer was just coming, asking me, and I guess he thought the question was gonna be changed, and I don't think they was changed.
Okay. Well, we'll get to that. Since you won't remember, that's fine. When you were asked by Mr. Shart about April 28th, 2015, Jeffrey Williams, he only asked you whether Jeffrey Williams was with you in addition to you and Mr. Zachary and Mr. Garlington. Is that right? Is my memory correct?
I don't recall.
Okay. Did you feel on December 28th, 2022, as able as you have felt in this courtroom this week and last week to tell the judge when you needed to do something like talk to your attorney? Did you feel as free to talk to your attorney or ask for requests to speak to your attorney then?
I don't recall.
You don't?
No.
Okay. Is there any portion of what the jury saw in your December 28, 2022 testimony where you halted the proceedings or what wasn't seen? Did you ever halt the proceedings on December 28, 2022 to ask to speak to your attorney?
I don't even know the words you just used.
Did you ever stop and say, Judge, can I talk to my lawyer like you have today and last week?
Like I told you earlier, I ain't sitting over there. I'm sitting up here supposed to be telling my truth. And it's like you're not accepting my truth. I wasn't sitting over there in County Blues. I'm sitting over there in County Blues. I'm in the free world. So it's like I couldn't stop and say that over there.
Why couldn't you?
Because I don't understand it. But once I got up there, I thought I could. Because you told me that. You said, anything you don't understand, you didn't tell me that December 28th, right?
Did your lawyer?
No. My lawyer didn't tell me to stop neither.
So sitting next to your lawyer, did you ask him questions? Not talking about what they were, but did you ask him questions at the table?
I would ask the witness to be allowed to answer the questions.
Judge, I'm not asking him what was said. I'm asking him.
Oh, no,
Sitting at the table next to the lawyer you had known for 15 years, were you able to ask him questions?
I probably could have, but I didn't.
And in the back, when you were with the lawyer you've known for 15 years, did you ask him questions?
Yeah, I told him.
Well, if he wants to share it, it's his to share.
I don't want to share it. Okay, I don't want to share it.
And I'm not asking you what. I'm asking you, did you?
She just said I didn't have to share it.
She said you didn't have to share the content. I'm asking
I don't want to share it. I don't recall.
I'm asking you, did you ask
I don't
the lawyer?
recall. I don't recall. There you go.
Are you saying that now because you're just frustrated?
Here you go again. Here you go again. Here you go again. Exactly.
Okay, I disagree. The question was, were you able to ask him questions in the back? And frankly, he answered it before he didn't recall. So,
thank you, Judge. All right. When you left court last week, did you wipe your nose at the jury?
What you mean?
Just that. Did you wipe your nose at the jury?
Yeah, when you asked me to do it,
I mean, when you got off the stand.
no.
Okay.
I wipe my nose at the chair. See, she going too far.
Until there's an objection, they just ask questions. But all these are capable lawyers, as is your lawyer. So
Yeah, but she,
I just call the balls and strikes.
you silly.
All right.
I swear you.
Just one moment, yeah.
She's silly.
I think she's almost done.
Yeah, I hope so. Before I go back left. Cause the whole mind going left.
What do you need to say?
Go back left.
Arguing back and forth with you.
Okay.
You just being petty now.
You felt differently on December 28th, 2022.
You would have changed everything. I want you to change. I probably wouldn't be going through. You probably wouldn't have gave me the deal. If you'd have came and asked me, I don't know, I'm sick of it, man.
I don't want to make you sick.
Well, let me take
Who are
a
you
break.
talking to right now?
Can I take a break?
Hang on just a second. Are you almost done? Because
I'm wrapping
there are
up.
some people who need a restroom break.
But we just give them that break, Your Honor, and I'll make sure that I'm.
Give them that. Yes, let's take a break right now. All right, we'll be in recess. Mr. Sledge back? Okay. Said Ms. Love, I see this email and Miss Persfield's, she's not with us, but she's back in the office, so you can add her back to the emails when you're sending stuff. Yeah, don't worry about it. Oh, I can do that. Amen. Cause, okay. That's in place until we get Mr. Wright back. I think our Sergeant Ingram just went to retrieve him. That's all right. We have you back here. What are we looking at? Whatever happened to it? Oh, you know. Thank you. Go ahead, Ms. Sullivan.
Believe that to everyone's delight, that's all that I have for Mr. Sledge right now.
All right, thank you. Is there any recross from any of the attorneys?
Not on the behalf of Mr. Stillwell.
Okay.
I
All right.
want to apologize to Ms. Lord, courtroom and jury for getting upset.
Appreciate that.
Your Honor, I'd ask that Mr. Sledge not be released, but be excused temporarily.
Okay, you are excused. You're still under subpoena, so there's a possibility that you might get called again at some point. If so, somebody will let you know through Mr. Wright.
Okay,
But
thank
you
you.
are free to go.
Thank you.
All right. Ms. Love, call your next witness.
Your Honor, the state calls I believe that I will be calling a lieutenant, but if not, it will be Mr. Wright.
Okay. Yeah.
State calls Mr. Derek Wright.
I do. See, state's very first last name from the state. Right. Derek, D-E-R-E-K, Wright, W-R-I-G-H-T.
Good afternoon, Mr. Wright.
Good afternoon.
Forgive me for putting you on this stand. This is not a place that I know you normally reside.
Sustained.
I want to take these away from you. Put these over here. Mr. Wright, I will not be getting into matters of privilege. I'll just ask you a few brief questions regarding your interaction with the state as it relates to the witness that just testified.
Okay.
First of all, would you please tell the jury how long you've been practicing law?
It's a year short of 30 years, so 29 years.
And how long have you known Mr. Antonio Sledge?
At least 15, probably longer, somewhere between 15 and 20 years.
And forgive me, but were you sworn in?
Yes.
Okay. And did you meet him first in your capacity as an attorney representing him, or did you know his family before you began representing him?
In a legal capacity first.
Okay. Do you know how many instances where you had to represent Mr. Sledge in Fulton County? Without saying a number, are you aware of how many instances?
If I thought about it, I probably would come up with an accurate number.
Is it, have you had at least 10 occasions to interact with him on not criminal matters, but just matters, legal matters?
When you say occasions, are you referring to cases or just interactions? I've not represented him on 10 cases. It's far less than that.
Okay. Over the last 15 years, are you comfortable telling the jury how many cases that you had an occasion to represent Mr. Sledge?
I would say, for sake of being accurate to this one and the one they've heard about from before, and I think a misdemeanor case. So other than that, I would be having to really dig deep, and I think that's probably it.
Did the misdemeanor case happen 15 years ago?
Probably more like 6 to 8 years ago, give or take.
So what was the first, when you say you've been his attorney for 15 years, what was the first instance? What year was the first instance?
Again, I can't tell you. I'm not being difficult. I just don't recall. I just know that I did come in contact with him as an attorney. And then with many of my clients, I developed a relationship. So he is someone that I've considered a friend, and I know him, some of his family. And therefore, I've had an ongoing interaction with him, both professional and personal, for 15 plus years.
All right. Is it fair to say he's not the only person that you've represented in criminal matters?
Correct. I've represented many, many people over
Have
the
you-
years.
Have you had occasion to represent many, many people in Fulton County over the years?
Yes.
Have you had occasion where when you make an entry of appearance with respect to, say, for instance, a bond hearing, but have been required to stay on as a person's attorney?
Early on, when I first started, you had some of that because, one, often you might get onto a case and then get appointed where the county pays you to stay with the client.
Okay.
So early on, there was sort of an advantage to getting on early, and then you could stay on if the client either retained you privately or the county paid you. Later on, that changed, and more emphasis was put on public defender and contract attorneys and other stuff. So I would say in the last 10, 15 years, not so much.
So if you signed on to represent a person in the last 10 or 15 years for one thing and wanted to withdraw, the courts have allowed you generally to do that?
Generally, it depends where you are. If you're in Toombs County, Toombs County don't let you withdraw. Once your name hits the paper, you're the attorney regardless of whether you get paid or not. There's some other counties like that. Fulton is generally pretty liberal, where Fulton, if you and the client come to a disagreement or if money, Mr. Green doesn't show up, that also is a reason that you can sometimes get out of a case. So from that standpoint, Fulton is a little more understanding that sometimes the attorney and client have to go separate ways.
Without getting into the specifics of what you may have shared with your client, unless he waives it and you've been given permission to, and you'll have to tell me if that's the case.
Well, I'll tell you now, he has not waived attorney-client privilege.
That is fine.
So I'm restrained by the laws
That's
of our
absolutely
state.
okay. Okay. So without getting into anything that is privileged information, would you tell the jury if information that is said between you and your client in the presence of others, such as Lieutenant Lancico, a lawyer from the state, whether that information is considered privileged?
It's a two-part answer.
Yes.
From an attorney-client privilege standpoint, that conversation may not be privileged because it's been said outside of me and the client, meaning there's more individuals hearing it.
Right.
From a plea negotiation, and whether plea negotiations are admissible in a court of law, that is beyond the attorney-client relationship, but an admissibility issue. And therefore, the question of this conversation isn't so much an attorney-client, but whether if it's a plea negotiation or it's the furtherance of one, is it admissible?
Okay. So have you been sitting in court during the entire time that Mr. Antonio Sledge has been on the stand?
Yes. Well, there may have been a 1 hour short period of time one morning where I had someone covering for me, but other than that, I've been here the entire time.
Were you present in court when he was asked by Mr. Steele about a June 2024 meeting in Fayette between Lieutenant Lancico, yourself, Mr. Sledge, and myself?
Yes.
All right. Do you recall that meeting in Fayette County?
Yes, it was the Starbucks in Fayetteville, my place.
And how would you characterize that? First of all, how long did that meeting last?
I would estimate maybe plus or minus 40 minutes.
And generally speaking, how would you characterize that meeting, the content, the purpose?
Often when you enter into an agreement with the state, you'll be asked to come in or meet with them to discuss questions they may want to ask, subjects they may want to cover. And basically, it's almost sort of like a prep session. And from the defense side, we're also trying to get an idea. What are you going to ask us? Where are you going with things? So it's sort of both sides feeling each other out. And that way, when we get to court, things can sort of go smoothly. And that was sort of what we anticipated. And that's generally what the meeting was. To be honest, we did not get into the details of testimony as much as I am generally accustomed to. Most of it was, Ms. Love, you getting to know my client and getting a feel for him, and vice versa. So honestly, a lot of the details weren't discussed. It was more of a feel each other out kind of meeting, in my opinion.
Okay. And do you recall me asking your client about any specific details of the case or the plea that he signed on December the 28th?
There was discussion at that meeting about the plea that he had signed, a couple of videos, and again, I'm generalizing because I don't have an exact memory of everything. And again, because you didn't get into a lot of the details, like, to be sure, there was no script, there was no, here are the questions you're going to be asked. It was a very generalized kind of conversation. There was at one point, which y'all have talked about, a point where he started to share because he volunteered it.
When you say he volunteered it, what do you mean? Did I ask him something about it?
Mr. Sledge volunteered the subject of what Mr. Williams may have said to him.
Okay.
And to be clear, while it definitely wasn't what you were asking, it wasn't on the subject you wanted to cover. Therefore,
You say the subject I wanted to cover. Please explain what you mean.
you were asking, and I don't remember, to be honest, exactly what the question was, but it wasn't responsive to the question. That's why it stood out. And when you heard what he was saying about Mr. Williams, there was an immediate reaction where it was, that's not what I'm asking you, is what you said to him. And he said, well, he went on, said what Mr. Williams told him.
And was that the part where he's saying he encouraged me to take? What part are you talking about?
This is what I've observed discussion in the courtroom about what he said about Mr. Williams telling him to take Woody to see the police. And the point was, as his attorney, as a defense attorney, I took it as that wasn't a subject you wanted to talk about and you weren't asking him about. But I can't say that I ever heard you say, don't tell the jury. It was nothing that definitive, but it was simply, that's not what I'm asking you. That's not what I've asked you to tell me. And ultimately, we sort of moved on from it. But it was just clear he very much wanted to say it, and that wasn't what you were looking for in terms of whatever the initial question was. So, but answering the issue at hand, I cannot say that you ever said, don't tell the jury.
And listening to the questions that I put upon your client during direct examination and redirect examination, where I've asked the question and his response has caused me to say, that's not what I'm asking. Would you characterize the interaction at that coffee shop as different than or similar to those type of interactions?
I would say, one, the overall interaction at the coffee shop was pleasant. No one was arguing, yelling, screaming, anything like that. It was very pleasant. You'd ask a question, he'd provide an answer. And then even when we got to that, it still wasn't combative. It was simply, that wasn't what I asked you, or what I'll ask you. It was, again, that just wasn't a subject you were going to be asking him about. So it sort of came and went.
And when you say that's not or wasn't a subject I was going to be asking him about, is it your testimony that my response had to do with the question? Your Honor, I'm not.
And honestly, he's a lawyer. He's gonna be able to handle it. I'll give you a little leeway.
Thank you. When you tell the jury that I said, that's not what I'm asking you, was your understanding that that's not what I'm asking you related to the question that I had just asked that he seemed to have not been responding to?
It was to the question, that was not the subject matter or topic you were asking a question to. Again, I did not hear it. And again, maybe I'm biased because this is what I do, but I did not hear it as an instruction to say, don't you tell the jury this, or I want you to only tell them about that. It was, that's not what I'm asking you right now. I'm not going to ask you about that. As in, so I did hear that extra part, but again, it just reinforced the idea that you weren't instructing him to limit his testimony in any way. It was just clear that wasn't a subject you planned on going into.
Mm-hmm.
So as a defense attorney, of course, yeah, my bell rang and I said, that's a hot topic, but it wasn't any ethical issue because I didn't hear you in any way try to discourage him or instruct him not to convey that information if asked.
Now, were you present or were you asked by anyone else whether that was something that had been said?
Well, I wasn't asked, but I will say I am defense bar through and through for almost 30 years. Just as I, in this situation, sort of call balls and strikes. I'm not on one side or the other. And when one side has contact with me, I'll reach out and have contact with the other side to make sure both sides are getting information. And I did reach out and contact Mr. Steele, I believe, or it may have been Max, to say, hey, we did sit down, we had a meeting. Quite honestly, you know, there's no big secrets or anything about the meeting, but I will say there was a situation where when one subject came up, it wasn't what she was asking about, but it resonated with me because knowing what the issues of this trial are, I knew my brethren in the defense bar would want to make sure they knew, Sledge knew, or was told by Mr. Williams to take Woody to the police. Now, I imagine they may already know it, but they may not have known that Sledge had that information. So just as the state was aware of it, I wanted to make sure the defense is aware of it. And I've also made him available so that if they wanted to question him, he could also be questioned by them. In other words, fair to both sides.
And were you present when Mr. Sledge was in communication via Zoom or some other way with Defendant Williams' attorney?
Correct. In fact, there's not been a single attorney that's contacted me, and it's only a handful of times, but they've always contacted me to talk to Sledge. Okay. Every attorney has shown perfect professionalism.
Were you asked by any counsel for any defendant whether the state ever instructed Mr. Sledge to not tell the jury that Defendant Williams encouraged him to go to the police?
Let me answer it in two parts. Yes, I have told them.
No, were you asked? That's the first question.
Oh, okay. Let me make sure I'm addressing the question because, you know, us lawyers, we like to talk.
So did Mr. Steele ask you if I told Mr. Sledge, don't tell the jury that Defendant Williams encouraged you to go to the police? Did he ask you that question?
I don't recall him necessarily asking the question, but I told him my observation of that conversation. And Mr. Sledge told him his observation of that, really on the same Zoom meeting. So he actually, without having to ask it, received it from both me and Mr. Sledge. And even at that time, I said, I did not hear it that way, but if my client says he heard it that way, then he heard it that way. So it's quote unquote, two people hearing the same thing may take it a different way, especially one who is a defense attorney.
Did I inquire that of you after hearing that from Mr. Sledge? Did I ask you about that?
We have talked about it, yes.
And did you tell me that you told Mr. Steele? No, I didn't hear that.
Yeah, well, I told Mr. Steele, I never heard you tell him, do not tell the jury. What I told you was that I've explained, I didn't hear her say that. I heard that she didn't seem to like that topic, but I can't say that I heard you instruct him. But my client insists that that's what he heard. So that's I know it's not a black and white answer, but that's the gray answer where my client has been very consistent saying, this is what he heard, but that's not what I heard. So I'm not gonna juice it up for the state or for the defense. I can only convey what I, in good faith, heard.
And is there anything in particular that you recognized or saw that made you think I did not like that topic?
Knowing the general idea of what the case is about, that ultimately the state's theory of the case that Mr. Williams.
Without getting into what you believe the state's theory of the case is, I'm asking you specifically what you observed that made you believe. And Your Honor, I'd ask.
That's not what she was asking, so no. Go ahead and ask your question.
Thank you.
I'm sorry, please go again.
I'm asking you what you observed me do or say facially, non-facially, verbally, non-verbally, that led you to believe in some way that I didn't like that topic.
The fact that you stopped him pretty abruptly, meaning as he was going into it, he sort of answered anyway. So it wasn't that you didn't yell, you didn't scream, you didn't do anything. It was just, as attorneys, what we're really good at, I know we don't say talking, but listening and picking up. And when I saw that all of a sudden there was sort of a screeching stop point, that's when I realized, maybe, and again, not knowing the details of this case, maybe.
So is that where you drew your conclusion?
Let him finish his
Yeah, maybe that topic, that point has some meaning and some significance. And that's where my thought was, okay, well, just as something may be significant about it in talking to the state, let me also make sure I've conveyed to the defense, hey, that might be some sort of topic. And again, I didn't know what he did or didn't do because my role sort of stopped pretty early in this. So again, my thought is if I'm neutral in calling balls and strikes, I want to make sure that they also are aware that may be a topic of interest. And but nothing about your body language or your mannerisms went to anything more than just, hey, maybe there's something there that someone needs to look into.
Did I tell him that's not what I asked in a way different than you've heard me say that when he's on the stand?
No.
Okay. And when I've said that's not what I've asked, when he's been on the stand, did you draw a conclusion that that was something I didn't want him to tell the jury?
I didn't draw the conclusion, but I did draw the topic was not the topic you wanted to talk about, which of course I said, why? But it wasn't, I didn't extrapolate from that, oh, you're trying to make sure he doesn't tell the jury.
Did you ever describe the meeting that we had as one where it was supposed to be kind of a get to know you kind of meeting?
Yeah, I mean, that's in truth what it felt more like let's feel each other out, get to know each other.
And before your client offered up the information, Doug encouraged me to go tell the police or take Moody to the station.
Mm-hmm.
Had I asked him any questions leading up to that?
That was towards the later part. You had already gone through some questions. I think we'd asked about video, we'd asked about the history of Cleveland Ave and the formation of certain gangs, notwithstanding YSL, but even before YSL. So there had been plenty of conversation, and again, more of a get to know who Mr. Sledge is, where he's from, what part of the city, how he met folks, like how he met Mr. Williams, and those kind of things. So this particular part that we've been talking about wasn't the beginning, it wasn't the middle, it was probably more towards the end. And maybe 10 more minutes of meeting.
Had I asked him anything about Donovan Thomas's murder?
We clarified, as we did earlier, that one, he wasn't there, wasn't involved, and clarified he doesn't have specific information helpful to the state or to the defendants about the shooting of Mr. When I'm blanking out that quick.
Mr. Thomas?
Yeah.
Okay.
I guess I know more so.
All right. Now, you mentioned videos. Were you present in court when I asked your client about the Lie to Your Mama video?
Yes.
All right. Do you recall in June of this year, while we were at that Starbucks, that is your spot, where I brought up the Lie to Your Mama video?
Yes.
Do you recall whether I simply went into, there's a video where someone talking about you lie to your mom?
I remember us talking about it generally because what was being discussed, not so much stated by him, but just discussed, is this is sort of a street topic. You might pick up on any street conversation where we're talking about, hey, you might lie to your mama, your daddy, your family, or when you're in court, you gotta tell the truth. But
my question to you specifically is,
weren't you finished?
Yeah, that was it.
My question to you specifically is, do you recall me asking your client? I want to ask you about a video where they're saying you lie to your mama, you lie to your kids. And your client saying, that's not me. Do you recall that interaction specifically?
Partially. I remember the conversation and the topic. I don't remember his answer being no. I remember that conversation led to a conclusion that this is something that's just said in the street. And he didn't necessarily have a point of origin of it or this or that, but it was just something that's in the street. So that's why I can't give you an answer to both parts of your question.
Mr. Wright, do you recall me telling your client, so is the answer you don't recall him saying that's not me?
Correct. Okay.
That's okay.
I remember it being played.
Wait, you remember a video being played?
I want to say, I don't know if it was played or we heard the audio.
On what?
Well, that's what I'm trying to remember because we only had phones. We may have had a laptop. Again, and I could be incorrect. That's why the safe answer is I'm going to say no, because my recollection of that specific point is not, I don't know if we simply talked about a video or if one was shown.
Okay. Do you recall me telling your client, I have a video of him saying that?
You may have, yes.
Do you recall telling your client, act as if the state is God and they know everything? They already know the answers to the questions they're asking you. So don't try to be clever, just tell the truth.
It is customary. But
I don't mind the explanation. If I said it wrong, just say, no, you didn't say that.
I don't have a specific recollection of saying that, but it's customary for me to tell my clients, when you are in a cooperating posture, when they ask you questions, assume that they know the answer to the question they're asking, that they're asking you not just to find out information, more often than not, they're testing you. They're trying to see, can they trust you or rely on your responses? Are you going to be truthful with them? So yes, it is likely I would have had that conversation. Would I have said God or some other analogy which made sense? Something. But it's more likely that I, at some point, made sure I said words to the effect of, when they ask you questions, assume they know the answer already. This is more of a testing, not a inquiry for information. So that's why I'm saying I may not have used those exact words, but I'm sure I probably did have that exchange in terms of the concept.
And when would you find it necessary to advise your clients in such a manner?
When they are in a cooperation agreement, and once we realize, they're putting us under subpoena, we actually have to testify. And then the posture sort of changed. That it's not just, hey, we're willing to testify. It's no, you're going to testify. And if you do, understand, you have to come in, you're gonna have to tell the truth. And the state's gonna question you and ask you some things. And when they do, that's when I would say, don't think you're gonna outsmart them and you're smarter than everyone in the room. You need to almost assume they already know the answer to the question. And therefore, being truthful is always in your best interest. One, it's the right thing, but two, it's the smart thing.
Prior to that meeting, had you already been made aware that your client would be testifying?
Well, yes, the purpose of the meeting was, they are going to have us testify.
Right.
So we need to meet with them and see what questions they're going to ask. And like I said, just as y'all are feeling us out, we're feeling you out to get an idea. Okay, what things are they going to talk about? Are there any issues that are going to happen? And based on the plea and the fact that there was, we'll just say, some tussling or adjusting in terms of what the state was thinking of his factual proffers and what he was thinking, I figured this would also be a good time to start to iron some of those differences out and make sure that we're all on the same page as to what he can testify to and what he can't.
So you do not recall saying that in response to my telling him that we have a video of him saying they lie to your mama and you lie to your kids and get in the courtroom and tell the God's honest truth.
I may have said, wait. That's the video you're referring to. You're asking me, did I counsel him about assume the state knows?
In response to my saying to him, I have a video of you, not anybody else I'm talking about, but I have a video of you and him sitting back smiling. And then you saying that you have no memory of that.
I may have, only because listening to the dynamics of the situation, that would have been a time it would have triggered me to say to him, hey, this is, make sure you understand, you need to be straight with them. So I don't have a specific memory, but just knowing that I've been doing this a while, okay, I'm sure I probably did.
Okay. Now, back in November of 2022, did the state seek, do you recall getting an email from me asking whether your client wishes to speak with the state about the case?
I believe November 17th. I could be wrong, but I believe that was when I received that email.
And you might have got one in November 17th. Did you also give one? I'm going to show you what I had marked and provided to counsel for the defense, but I'm willing to show again as State's Exhibit 450 Yankee. If anyone wants to see it. Sure.
I left him.
Yes. Yeah. I'm gonna take 10 minutes. Oh, I know what it is. I still have this one. All right, we're gonna take, oh, it's 10 minutes or so, maybe 15, maybe longer, who knows? To give them an opportunity to look at a couple of things. You're free to stay or free to step out. Do you want him to step out? Or, yes, okay. Do you mind stepping out? All right, y'all all take a minute and
Judge, may I just, so that they are clear for the record, exactly which one is which?
Sure.
So State's Exhibit 450 Yankee is the proffer, it's the email dated November 30th, 2022 at 5:44 p.m. From myself to Mr. Wright. And it is, the attachment is proffer form / it says, "Good afternoon, Attorney Wright. It is always good speaking with you." That's the one labeled 450 Yankee. The one labeled 451 Yankee is the email sent from me to Attorney Wright that is labeled / agreement and dated December 27, 2022 at 4:57 p.m. It starts, "Here you go, Derek." And attached to each email is the attachment that was sent at the time the email was sent. Then 452 Yankee is another email to Attorney Wright that says / agreement updated, and it is December 27, 2022 at 5:06 p.m. with the attachment / agreement updated. 453 Yankee is the email sent to Mr. Wright from me, dated Wednesday, December 28, 2022 at 1:45 p.m. And it is labeled / agreement updated to. $454 Yankee is the email sent from me to Attorney Derek Wright at Wednesday, December 28, 2022 at 1:46 p.m. Labeled / agreement updated to. And then 455 Yankee is the email from me to Attorney Derek Wright, labeled / agreement updated to, sent Wednesday, December 28, 2022 at 1:54 p.m. And the body of the email says, "Use this one!" And attached is the agreement or the updated agreement to. And then 456 Yankee is the email from me to Attorney Derek Wright on Wednesday, December 28th at 2022 at 2:34 p.m. labeled / agreement updated 3.
okay.
And that's it.
All right. And do you plan to potentially utilize all of these exhibits?
Yes.
This witness, okay.
But they're also included. All of them are also included in the email that I sent.
Yeah, I see each of those in that email from about an hour ago. So you'll want to take a few minutes, those of you who haven't had a chance to look at them, and look at them. All right, I'm going to step off the bench for a minute to handle another matter, but I'll be back in 5 minutes or so. hadn't discussed everything yet, so we'll call you. You can go ahead and remain outside. We'll let you know. All right.
I need a few more minutes. I've got 7 documents that I'm going through, trying to parse out what is different between each of those documents. I'm on number 5, and we're doing it together.
It might be easy. Do you want to tell them what the differences are in each document? That might make it easier. You probably know what they are. You've gotten through 5 of them? All right, so just on between 5 and 6 and 6 and 7 then. Which would be, I guess, between 454, 455, and then 456. Apparently. Okay, so that won't make it any faster than I thought maybe it would, but that's fine. So are you going to be asking details about, is it what the changes were or just that there were changes?
That there were changes in potentially what they were.
Okay. All right.
I guess I'll wait until we're ready to discuss the whole thing. I've got a position in regards to the admissibility of all of these documents.
Okay, what's that?
Let me say this first, though, because we did have a discussion previously about candor. I made a statement when we were at the bench in regards to what I thought was the applicability of Code Section 24-4-410. Taking a closer look at it, I don't think it applies.
I think you're correct that it does not apply.
And so let's
right.
take that off the table.
Right.
I will tell you that my overall objection is that I'm opposed to any of these documents coming in for a couple of reasons. And I know what the state has described them to be, that these are correspondences between the state and Mr. Wright in regards to this evolving, allegedly, plea agreement. I'll state for the record that the one thing I do have is an email, the initial email from the state to Mr. Wright.
Mm-hmm.
I don't see, and we've not been provided, and the state can let me know whether they have them, any responses, email responses from Mr. Wright that would kind of inform us as to what are the discussions that are going back and forth. So I don't know what Mr. Wright's responses are. If he, for example, sends some suggestions as to this is what I want changed, or this is what my client says. So I just don't, I can't address that. But in addition to that, my recollection from Mr. Sledge's testimony, ultimately, is that he indicated that there were changes made to the agreement. that he suggested changes, or he told his attorney that some things needed to be changed, and the state declined to change some, and they did change some. He ultimately admitted that. And so if the intent of the state by trying to introduce these documents is to show that there were changes made, well, that's not necessary, because that's come out through the testimony. Now, if they want to, if their intent is to say that there was a specific change made to maybe a specific section, that can also come out through testimony. If this witness, Mr. Wright, and I presume he does, that he would know that Section 8, and I'm using that hypothetically, Section 8 of the agreement was changed from this language to that language, and he can testify to that. But I don't think that the wholesale admissibility of all of these documents is really necessary to prove the point that the state is attempting to make. And Mr. Sledge was on the stand. He could have been confronted if the state's intention is to give him different versions and say, well, didn't this change from version number 1 to version number 2? He could have been confronted with that.
Well, I mean, she could have maybe tried, but I'm not sure that that would have been successful, since these are conversations and correspondences between Miss Love and Mr. Wright, not between Miss Love and Mr. Sledge. So I don't know that. I mean, I think he even said, I don't know what got said between my attorney and her. I just know what my attorney and I said. So that wouldn't have gone very far. Yeah. So do you have an evidentiary objection to these, or just, I don't really want it?
Well, you know, they're not, I don't believe that they're prior. It's not a prior inconsistent statement. I don't know if they're trying to introduce them as impeachment. If that's the case, then I would suggest to the court that there are not prior inconsistent statements of anyone. And I would say they're not relevant, that under 403 there, it's a waste of time. Okay. It doesn't prove any point that's at issue in this case. Certainly this witness can testify.
All right, well, at this point, those are overruled. Are we ready for the witness now? Two minutes. You can have 2 minutes, Mr. Sharp. You can talk during his 2 minutes if you'd like to.
Yeah, I was just trying to support Mr. Adams here a little bit, because we're essentially with these different documents. The documents didn't even come through on my email, so I was sent them afterwards. But we're just trying to identify the changes. So it's just taking us a minute to go through all.
You get 2 more minutes.
I didn't get an answer to that question. Maybe I didn't direct it to the state.
Okay, well, I don't know whether they've got the responses or not. I don't know whether they want to use them or not, but he is on the stand. So if they don't end up using them, maybe y'all can get them in if you want to.
Well, but we don't have them if they exist. And I guess I'm asking the state to indicate whether or not those items exist.
Were their responses?
I think that when Mr. Wright responded, it was via telephone call. I'll check my email to ensure that I'm not inaccurate, but I think that it all happened. I would send him something, we'd have a conversation, I'd send him something in response, but he can correct that. And if I won't touch it. But I'll check my emails for all emails from Mr. Wright.
She'll check while y'all are doing that last bit of review.
forward all the emails that I got from Mr. Wright.
What else, Mr. Short?
I'm prepared to talk for 30 seconds, Mr. Adams.
Okay,
So
all right, go ahead, Mr. Adams.
my concern here is, again, I don't know the logistics of how everyone's planning on doing this, but for instance, there is a older version that was not adopted by Mr. Sledge. That was the version, Mr. Williams, could you pass me, Mr. Williams, could you pass me this? Yeah, thank you. So there's a version, the final version of version 2, which was then changed to the final version of the plea agreement. And it says under number 8, the language, as we've already heard the state read about laying low. And then it says, and during the meeting, this is the meeting at the home, defendant, which would be Sledge, personally heard a YSL associate state, I caught that N nut down bad. Now, clearly, this is something that Mr. Sledge denied happened and has been taken out of the final plea agreement. But why? What my concern is exposing the jury to things that are not true.
So, yeah, I understand that. So I'm not sure exactly what Ms. Love's intention is with all of the different versions and whether she's gonna ask that it be, you know, that kind of detail come in, or whether it's just gonna be, you know, was there some additional quotation or something on there that then got removed? So Ms. Love, can you shed some light on that?
Yes, Judge. As it relates to, I think I have asked Mr. Sledge, in fact, certain things, and the objection was that it was, of course, a document that wasn't in evidence, and I should not refer to it as a prior version, where I was trying to get him to compare something, one document to another.
Right.
So the intent here is to show the jury that changes were made at Mr. Sledge's request and certain changes were not. And I just actually found, in response to questions from the defense about responses from Mr. Wright, and I just emailed it to them, an email from Mr. Wright to me on from back then. It looks like December 27, 2022, where he's enumerating certain things and responding to it and making recommended changes. So there are certain things that I would agree just don't need to be said. They serve no purpose. And it would be just as beneficial and serve the same purpose to say number 8 is different and I took out certain things, as it would to try and put in all that language. And that just doesn't seem necessary to put in that, some language that might be considered inflammatory, that the state thought was the case and they said no, it wasn't. Just the very fact that they had us take out language is what the state feels is important that the jury knows.
Okay.
So no, to the extent that, and if I don't think
I guess if you are going to tender that for admission, then that can be redacted and it can just show there was something in quotes that was then removed.
Yeah, I like that idea, and I'll, if necessary, I can really quickly go out and talk to Mr. Wright. But right now, I don't expect to have him read certain things, and I know he's a lawyer, so he won't do it unless I tell him to. So I think that we're okay there.
Okay. All right. But was there anything else I'm sorry, did you have more?
I was just saying that I was still sending them over the emails from Mr. Wright.
All right. Was there anything else in particular that you feel like if the particular document does come in, part of it needs to be redacted out? I think we're all in agreement.
We just got an email, Your Honor, which has Brady material in it. Was just sent to us.
I haven't seen it. It didn't.
10 seconds ago. Yeah, it's interesting.
I don't have it yet.
Yeah, It's kind of coming through slowly, some of us
Okay.
quicker than others,
All
and
right.
I'm having it printed out. And I know we've got the jury back there waiting, Judge, and I'm not trying to belabor anything,
No, no,
but this is trying to kind of handle this on the fly as we're getting emails
I understand.
in the middle of this.
Okay.
And
Sure,
we're-
thanks.
And we're also having 8 copies sent over for the court and the defense and.
Is this response the one that is gonna change to the final? So I should be looking at the one just prior to the final when I'm looking at what he's saying?
I'm sorry, wait, what?
Which version is this in response to?
Okay, so I don't know what was just given to you, but
I get the same, this is what Ms. Love just sent to y'all or what? Okay, so whatever you sent over at 4:12:36 PM today. That was Mr. Wright's December 27th, 8:43 PM response. What?
So the December 27th. Hold on. So December 27th, 8:43 PM. No, well, that was one version. We talked more in court, so obviously there were other versions.
I'm
that
just
was-
wondering what I should be looking at when I'm seeing what Mr. Wright's talking about.
So, if it's December 27th, 8:43, let's see, going back to December 27th to a
So
December
it's gonna be the 5:06.
It will have to be.
4:52
Yes, that looks right. That looks correct. And then
Right.
December 20, but there were other versions sent back as we talked more in court the next day. December 28th, so 4:53, 4:54.
I know.
Your Honor.
Yes.
To answer your question, this email sent by Mr. Wright on the evening of December 27th would have been between the sledge agreement updated and sledge agreement updated 2.
Okay. All right, that's what I thought. And is the alleged Brady, what is that? Item number 3? I haven't read it all yet.
Sir, I haven't either, but certainly number 3 is absolutely Brady.
He said it was not.
And it also obviously conflicts with what they kept as his factual acknowledgement. So it's clear, A, that Mr. Wright was telling them that's not true, but it's still maintained, they still kept it as a factual acknowledgement.
Okay, well, this isn't actually saying that's not true.
Well,
It's saying the real issue was,
well, the factual
which he
acknowledgement,
actually denied on the stand, but
the factual acknowledgement says while associated with YSL to support and express loyalty to YSL. And then it says, and wherein on behalf of YSL, defendant threatened, and it's all goes to intent and state of mind, and that's the important part of this case. You know, no one's denying that the video was made, but what is the reason behind it? And from this email, Mr. Wright is clearly telling the state in an email on December 27th, the video may have seemed like an issue was gang related, but it was actually about a girl that Sledge was dating, and Kel started kicking it with her. That was the real issue behind that. Not denying the video, but the real issue was the girl. That is Brady. That was never shared with us.
Okay, I'm not sure that that's Brady. I understand you to be saying that you think this is a denial of it being something done to support, and I don't know what the language was, support and whatever, the gang.
Your Honor, that's the crux of the case.
Yeah, no, I know. And a whole lot of this, y'all are gonna have to ultimately argue to the jury your various sides, but for this to say, it seems the video may have seemed like the issue was gang related. The real issue was the girl that a member of a rival gang was then sleeping with, that was one of the alleged gang members' girlfriends. Might make that the real issue, but it doesn't necessarily make it in no way in support of the gang. And I mean, y'all can certainly argue that, but I don't think this is the kind of thing that is like, oh, this is, plus this wasn't the ultimate version. So I don't know what went back and forth after that. He ultimately signed with his attorneys. I don't know what the advice was, but knowledge, something that said whatever the ultimate number 3 was. And you know, y'all made and y'all have secured evidence from the witness that he feels like he was pressured and coerced into that, and reasons behind it. So y'all have an argument there too, but
I think we've done a good job doing that, but we did all that without the knowledge of this email, which should have been provided to us by the state. That's my only.
And for what it's worth, the you know, a significant portion of the state's questioning and then a redirect of Mr. Sledge focused around whether or not he had there were specific things that he had asked that they change. And so what we end up having here, what we know now from the email that we didn't have before, is that, again, going back to number 3, number 3 as in its final form talks about being associated with YSL, and you know, talk about the video and where he's brandishing a weapon using a drive-by shooting to harm a person named Kel, a rival gang member. But the state knew, certainly when they were redirecting Mr. Sledge a little while ago, that Mr. Sledge, through his attorney, had given them the information, had specifically denied that number 3 was accurate.
all right, y'all are saying had specifically denied, and I don't read it that clearly. I don't think that's a specific denial. That's more of like I'm clarifying that this is really more about the girl than anything else, which it frankly is. So, okay. I mean, I hear what you're saying, but I don't read it that way.
If you look at number 4 also, Your Honor.
Okay.
Number 4 of the defendant's factual acknowledgments, and you gotta excuse me because I'm kind of flying back and forth between the different versions.
Yeah, we all are.
But you know, number 4 talks about on April 28th, as reflected in the indictment, that the defendant and fellow YSL associate Beniki and Garlington, I'm just reading it into the record so I can perfect it, committed a drive-by shooting using the firearm defendant wielded in the video reference in part 3 of this section. So I'm looking at the email that we just received.
Right.
And it gives a whole total different accounting of that. where, and of course, this is coming from Mr. Sledge because Mr. Wright says in his email, he said he didn't know because he was cool with Peanut, who was seeing his cousin, would even be at family reunions together. He thinks shooting Peanut was not planned, but more impromptu, or at least very short or little planning. He said he didn't know until after it was done when it came on the news. He had been watching the Patriots versus Steelers games with it, then the news reported it. You know, so this again, and what you've got is the state directing and then redirecting and challenging Mr. Sledge on these very specific factual allegations and whether or not he had told his attorney that, or whether or not he had suggested that that be changed in the agreement. And what we have here, what we know now, is that Mr. Sledge was in fact sending those, you know, correcting these very specific factual allegations, sending them to the state, and the state, well, because it doesn't appear in the factual acknowledgments, the state ignored it or they refused to make any
Okay,
changes.
so I'm not sure what y'all are looking at, because the version of number 4, factual acknowledgement number 4, that Mr. Wright is speaking to in this email that he sent on December 27, 2022 at 8:43 p.m. is, we agreed, at least Mr. Shart and I agreed, was Sledge agreement, the one that is 452Y, from the one that's called Sledge Agreement. Well, there are 2 that are called Sledge Agreement Updated, but this is a correspondence between 452Y and 453Y, but ultimately the end product. After the one labeled Sledge Agreement Updated that came from 12/27 at 5:06 p.m. And that one reads, on January 10th, 2015, before the murder of Donovan Thomas Jr., defendant had personal knowledge that YSL associates were planning to murder Donovan Thomas Jr. Mr. Wright's response to that is essentially, Mr. Sledge does not think the shooting of Peanut was planned, but more impromptu, or at least very short or little planning. So that clearly got changed, because our final version doesn't say they were planning to. Yes.
May I incorporate? So I cross-examined Mr. Sledge, and the state's theory is that there was a, quote, gang war starting in approximately the fall of 2014.
Right.
That escalated with the fight on January 6, 2015 of Mr. Copeland at the Club Crucial. And then it culminated and then went on steroids thereafter, after January 10th. I would have used number 4 that you just read, Your Honor, to show that there was no animosity between Mr. Sledge, who's a supposed YSL member, and Mr. Donovan Thomas, who's a supposed leader of a, quote, rival gang. The reason I say this is because I knew about it. So listen, I want to make it clear. I knew about it because I spoke with Mr. Sledge through his lawyer. So I actually asked these questions.
Right.
I didn't know about this email.
So
But the email.
Go ahead, I'm sorry.
But no, don't apologize. But the email is Brady, because what the state was saying is these 2 divisions. They put, I didn't put Mr. Sledge on YSL, and that there is a total collapse between human beings. And that, to me, you know, I learned Brady to be anything that is potentially exculpatory or impeachment or mitigation. And the court has heard now, you know, Mr. Copeland said I lied about everything. That to me is Brady. The statement on this number 4 is to me Brady, because it shows that there is not animosity.
All right. So your belief about the Brady is not the part that I was talking about, but more the part that says he, and he here is Mr. Sledge, at least at the beginning. He said he did not know because he was cool with Peanut, who was seeing his cousin and would even be at family reunions together. Does the he change there, and is the he become somebody else was cool? Who is the he that was cool with Peanut? Do we even know? We don't.
I believe that is Mr. Sledge.
Okay. And Mr. So you think it's Brady material that Mr. Sledge was cool with Peanut?
Right, because Mr. Sledge is he's been identified before you came on the case, the bench on this case, as from multiple, two, definitely, maybe three, supposed gang experts saying Mr. Sledge is part of this gang.
Yeah.
So to me, and it just fits into the whole, I thank you for allowing us to get these emails, but these emails there's a special duty here. And this is not the special duty, I don't believe.
Okay, so
I'd like to see all the emails from Mr.
I think she's looking and sending all that she has. Is that correct, Ms. Love?
Two things, yes, and when the court permits me an opportunity to respond to all of this, I would appreciate that opportunity.
Okay, what was the second thing? Or one was yes, and two, you want an opportunity to respond. Okay, all right. So Mr. Sledge has been available to the defense to speak to as well. We just heard that from Mr. Wright, in fact. And so I'm sure that Mr. Sledge, if asked, would have told anybody that asked, especially the defense, what his relationship and thoughts about Peanut were. So
He did, and I even asked him about it, and he answered similar to this.
Right.
But that really is besides the issue. The issue is that the prosecution has to do. There's one thing. There's a Brady duty, and then there's a Brady violation. There's no violation because I knew about it, and it came out of court. But there is still the duty.
okay, a Brady, I mean, we all know what Brady material is, I hope. And if something is equally available and as easily gotten by one side as the other, that sort of takes it out of the realm of Brady.
I don't agree with that respectfully because what if I didn't do my job? It's an ineffective claim.
Well,
and the state had the duty.
All right. Well, I don't.
You can't shun your duty and say, well, he has the Honorable Keith Adams, so he'll figure it out on his own. That's not. In fact, courts ask this court, I believe, but other courts in this courthouse say, is there any Brady evidence known? Is there any evidence suppressible known by the state? And they give it to you where they're supposed to. So I don't agree that, hey, go find it for yourself.
Well, I don't read that part of number 4 to be Brady. Yes.
May I respond to number 3 though? I mean, the state provided us with a plea agreement with factual acknowledgments that appear on its face to be Mr. Sledge acknowledging certain things were done on behalf of YSL to further YSL. I don't have equal access to Miss Love's emails with Attorney Wright that she has. So clearly that email correspondence between Mr. Wright and Miss Love, which was never handed over until a few minutes ago, it contradicts and it impeaches those factual acknowledgments that Antonio Sledge signed. Now, I'd like to think that I do everything I can as a defense attorney, but I don't think it's unreasonable that a defense attorney would read the factual acknowledgments signed by a cooperating witness and accept that that is going to be their stance when they come and testify. And
well, lucky for y'all, it wasn't his stance.
Well, but I don't think that makes us getting it this last minute any less problematic.
Well, I'll just say that if the state has an open file, then none of these arguments ever even come up. Now, I know that that is your you know, something that y'all in your office can make a decision about, but open file would, just exactly what I said. So, okay, Ms. Love, what do you want to respond to? What do you feel like there still needs to be a response to?
Your Honor, I think that the court sort of encapsulated the position that I have pretty well. So you sort of took away the many of the responses that I had. And so, in as much as anything else that Mr. Wright sent to me is being printed out, I think we have them all printed out. I'm going to send them over and disseminate to the counsel for the defense and to the court.
Okay, thank you.
Do I understand that to mean that there are more coming?
It sounds like it. Should I just send the jury home for the day? Can you release them for the day? Tell them they're under the same instructions they always are. Thank you. They're always here at 9. And I'm just gonna put on the record that in terms of what is and is not Brady, I mean, the Brady v. Maryland case establishes it, and there's all kinds of Georgia case law that sort of reiterates it. And one of the prongs is definitely that the defense did not possess the evidence, nor could the defense obtain it with any reasonable diligence.
Disagree, respect, that's a
Well, I mean,
violation.
you can disagree with it, but it's what the case law
That's
holds.
that's because the case law in the appellate opinion is saying the defendant, the accused, convicted person, the criminally accused is now complaining and wants the case reversed because of a Brady violation. And then there's a 4-part test. And one of the parts is, was with due diligence this information accessible? I'm not saying that. Before that, there's a Brady obligation. That falls upon the state, whether it's easily accessible or not. If 2 experts say different things and the state puts them both on the witness list, but doesn't give the accused to say, hey, one expert says actually it's favorable for your client, and they hold back that report, that's a Brady obligation breach. Now, the fact that I was on notice that there's another person on the witness list, you would expect me to interview the person, and I would have found out about it.
I mean, I think I understand what you're saying is that if it is exculpatory or impeaching, there is an obligation to provide it. Okay. I guess I am looking at it from the position of, if you are claiming at this point, here's another Brady violation, I have to look at what are these factors, and I don't find those factors to exist here.
And that's why I thought I always said I knew about it, so I'm not saying it's a violation, but it is an obligation of the state. We shouldn't be getting it. I should have really had this before I cross-examined Mr. Sledge. Should have had it before trial. And Brady, the way I understand it, is an ongoing obligation that triggers immediately.
Well, okay, again, I don't read it in the same way that y'all apparently do. And I can't imagine that you would have wanted to use this particular exhibit, because if you used part of it, the rest of it could have come in, at least with regard to what's in each particular number, and the entirety of what's in number 4 I do not think would be beneficial to the defense side of the case.
This exhibit, are you referring to the email or the?
Not the exhibit, I'm sorry, bad word if I use that. This email from Mr. Wright of December 27th at 8:43 p.m.
I would like the opportunity to decide what I'm going to use and not. How about that?
Understood. I guess we can tell Mr. Wright he can come back tomorrow at 9. Thank you. So have you, did you say you were going to print or you were going to forward the whatever other emails there were?
I have printouts.
Okay. You want to dole those out to everybody?
Yes. Yeah. Since I gave the court a safe for that, the court trustee
Yes. And maybe we need to get an extra stapler down here. Okay. Just gonna give a little.
in the record
Yes.
for you? In Ray Haney, Haney. And that's 355 Georgia Peel, 658. It's footnote 1. It's 2020. And it reads, the state has a duty under Brady versus Maryland and Giglio versus United States. Giglio is Giglio, to disclose favorable evidence to the defendant in a criminal matter. This includes disclosure of impeachment evidence which could be used to show bias or interest of a party on the part of a key state's witness. And I say that solely because I don't believe what the court was saying about the 4-part test. That comes afterwards, after a person is.
Right, I thought I clarified that. All right, thank you. How many, is this just one more email or is this a few?
This is a series of emails, the emails that I got from Mr. Wright. I think I had him print out all of them that he sent me.
Okay, and so this will this stack include the 2 that you sent electronically or no? It's fine either way, I'm just wondering.
I think so. I think I asked her to send out all of them.
Okay, all right. And you've got a copy for each of the 6 defendants and a copy for the judge?
Yes,
Okay.
and also, to the extent that I enter any of these, the copies that I'm giving to everybody, it includes everyone that I email them to. I'm gonna take off that portion.
Okay.
And it will only include the email correspondence between me and Mr. Wright.
Thank you.
So.
Thank you.
Your Honor,
Yes.
let me inquire of the court, because I want to be really careful about this.
Okay.
Mr. Wright, of course, is on the stand. He's a witness. He's been sworn. He's testifying. And my general thinking would be, well, we're not really allowed to talk to him at this point.
I would think that's accurate.
Right. My thinking though is, as we're sitting here talking about it in regards to the email exchanges, and I'm not casting aspersions on anyone. We've received what the state said that they have in their possession, although they initially said that most of the correspondence by phone. And I don't know whether or not there are additional email correspondences that may be in Mr. Wright's possession, and maybe not in the States. And
All right.
I wanted the court.
Let me suggest that if you want to send an email to Mr. Wright, copying the state and saying, if you want to identify him, we've got, the email of whatever date, whatever time. If there are any others, can you please forward them to, everybody copied, which would be all of the attorneys. You can certainly do that.
And then I'll copy the court on that email as well.
Okay.
Your Honor, may I request that the email simply request of Mr. Wright to forward everybody all the correspondence related
As
to.
well, sure, I guess that would be cleaner.
Yes, thank you.
That's fine. If you want to be the one that sends out the email, that's fine too.
Thank you.
Okay.
You know what? One moment.
And you know what? Whoever sends it out, you can say, we all discussed it in court with the judge and the judge is fine with it.
Sure. We don't have any problem with the state
Okay.
sending that out. He's their witness technically at this point.
All right, so Ms. Love, if you wouldn't mind doing that this evening. Okay, great.
She's happy to provide him even with this copy here that.
Yeah, if you want to do that, if that would make it easier, or if you just want to say, hey, can you send everything you've got? However you want to handle it.
I will do both.
Okay. All right, so the additional ones that we all just got handed, it doesn't look like there's much substantively that's new from what Ms. Love already had provided electronically. It's more, but it's not really new. Is there anything else we need to talk about before we break for the evening? Yes.
And then the investigator who's been in court, so I don't know if that matters, but
So will you call both of them, or?
I will call both of
Okay.
them. So Lieutenant Lancico she's been tasked with specific things as relates to
Okay.
this case, but I did not, at the time that we put Mr. Slade on the stand,
Have any idea you'd be calling
I didn't
either
expect
of
to
them?
have to call either one of them, but since we do, obviously, there's case law that.
Yeah, it doesn't exclude them from being a witness. If you want to bring up, you've been in court the whole time, that's fine, but.
and then the next witness is what I was getting, just.
Yeah, so hopefully the two of them won't take the entire day, or to borrow a phrase from Mr. Steele, God forbid, more than a day. Do you have the next witness available tomorrow as well?
We are attempting to secure a person who's not trying to be secured, but who is under subpoena.
Okay.
And we also have Mr. Thomas Burnett.
Okay, so you'll have somebody available tomorrow.
We do.
Do good, okay.
Yes.
Yeah. Yes, sir.
I'm waiting for you to finish that
I'm
topic.
done, I'm done.
Yeah, the only thing I was going to request is for the other defendants who have pled out, if there are similar email communications between the state and that attorney where they were going back and forth on their acknowledgements. So, for
That's right.
example, for Mr. Arnold, Mr. Stevens, Greer, Kitchens, Mr. Lee, Mr. Sumlin, Mr. Beebe, instead of waiting till the last minute or maybe not getting it at all, could we have that email communications as well?
How do you feel about that, Ms. Love?
Judge,
Why don't you take a really careful look at any of those that might exist?
Okay.
And if there needs to be an in-camera inspection, there can be an in-camera inspection. If you want to just share it, you can just share it. But go ahead and find whatever might exist and take a careful look at those and then give us an update.
Thank you.
And thank you, Judge, for saying what I think you said. Take a look at whatever exists, because I was going to add to Mr. Weinstein and say not just email correspondences, Just so we don't end up again with me saying, oh, you know what, I forgot to ask about these other correspondences. So any correspondence whatsoever in regards to those.
If y'all did snail mail, if you did text.
There you go.
Anything like that. Okay.
Thank you, Mr. Adams, for that broad document request. I appreciate that. Appreciate it.
Okay. Anything else? All right, I'll see y'all at. I mean, honestly, y'all, even when we're started at 8:30, it's 9:30 before we pull the jury in. So I'm thinking since we've got some stuff we might need to be discussing tomorrow, 8:30 in the morning for all of us. Okay. Hmm?
We could do
8? No, I don't want to do 8.
Okay.
I don't want to do 8:30, but no, we're not doing 8. I need my sleep. All right. See y'all tomorrow.